today's list, my lord. My lord, I am for the respondent vote 5, my lord. My lord, matter may be adjourned for 2 weeks, my lord. This is new matter, my lord. In the meantime, my lord, I will file my
An
affidavit.
interim order?
No, my lord.
Have you taken the permission from the other side?
Yes, my lord, I have taken of my lord.
With the consent, upon taking consent from the petitioner, counsel for the respondent number 5
I,
seeks for an accommodation. List this matter on 25th, 23rd of September.
May I please to lordship?
but, my lord, let it be, my lord, before my lord 20. My lord.
Why?
20 September.
Can't be.
My lord, already, my lord, a senior has been engaged, my lord.
I can't help
And
you.
he will not be available after 20 of September, my lord.
And he will come
So
back on.
15 September, my lord.
When is he coming back?
My lord, after 22, my lord, 30 of September. He will
This
come back
matter on
October.
5th of October.
May I,
Obliged, my lord.
may I please to lordship? Lordship, I beg to, with the consent of other side, I beg to mention item number 14, lordship. This matter may be adjourned for today, lordship.
My lords, I appear for the APDCL, my lords. The lordships have directed us to produce the reports, my lords. I have the reports ready. Matter can
What
be
is the
taken up.
matter about?
The debarment of the petitioner's firm from the approved vendors list of the APDCL, my lords, based upon certain tests carried out by an NABL laboratory with regard to allegations of inferior quality material supplied by them, my lords. The debarment order has been done away with by the APDCL, but the reports are ready, my lords. I can place them. The matter was, lordship had indicated that the matter can be disposed.
Why is the debarment order has been done away by you?
Yes, my lords, yes.
Why, why the matter is pending?
My lord, for the furnishing of the reports, my lords.
And why is it required?
Lordship, actually not for furnishing report, actually after passing of the interim order, they have debarred us. And and in that case, we have filed an IA application, and just before the listing of the IA, they have recalled that order. Department
That
notice.
order has been recalled.
Recall
The-
just before the day, just before 1 day, lordship.
Now, because of the pendency of the proceedings, you are not in a position to proceed with the debarring.
Yes, my lord. Now, we issued a show cause notice to them. They had,
It can we adjourn. it,
Lordship, actually
as
today-
As per his request, we adjourn it. We say that it is not, there shall, pendency of the requisition shall not be at a bar to initiate the process.
my lords, then my lords will kindly observe that the reports have been furnished to them, my lord.
Lordship may be taken on Monday because the senior counsel is not available today, and moreover, I am also busy in election, Lordship, because I am a candidate for the post of executive member above 15 years in bar election today. That's why I am seeking a adjournment for today, Lordship.
Monday, that my
Maybe on Monday and Friday, any day, Lordship.
Right to vote, he has said.
sorry.
Lordship.
Try to contest for him, my lord. Try to contest, my lords. Monday, then. My lord.
At the request of the counsel appearing on behalf of the petitioner, that he is contesting the elections. Day. Matter stands adjourned to be listed on Wednesday.
Then on Friday, Lordship, because on Wednesday the senior counsel may not be available. Maybe on Friday, Lordship. Friday 21st, Lordship.
But to
Okay, Lordship. Wednesday, Lordship.
Deeply.
Lordship, interim may continue till that.
what in time?
Yeah, not to take.
They have already
we've already-
removed the debarment. What is that?
No, Lordship, no, not to take any coercive action.
That this type of orders I don't pass.
Lordship, already
I
interim is
don't
there.
pass, neither I extend.
Lordship, till the next date only, till Wednesday, Lordship.
Then to the matter.
Lordship, today it is.
Anyways, you are not, nothing to do. During the election, you should not campaign. So
Sir.
we'll hear the matter. We'll hear the matter.
Lordship, then Wednesday, Lordship. Wednesday. Deeply obliged, Lordship.
Deeply. Deeply, lordship. In item number 18, my lord, I want to file a reply.
You are for the, what is
Petitioner.
the matter about?
We are
Lordship.
challenging the award of the labor court. I am not a petitioner. In
You are-
item number 18,
What a petitioner. You are challenging the award of the labor court.
Yes, my lord.
We'll have it when the matter reaches, we'll issue rule, keep it for hearing.
My lord. Lordship, I am for the respondent.
We'll hear, wait, matter is not adjourned.
My lord,
Yes,
Yeah, please,
Mr.
Your Lordship. Lordship, item number 41 and 42 have become infructuous, Your Lordship. The
Infractions.
debarment order have been revoked by the debarment order passed by AMSCL have been revoked. I've informed
Mr. M. Sahewala, the learned counsel appearing on behalf of petitioner submits that the debarment of the firm
Firm
debarment
debar.
order, which is impugned in the instant proceedings, have been revoked. Mr. D.P. Bora appears on behalf of the Health Department. Taking into account the above, the writ petition therefore stands closed as it had become infructuous. Interim orders, if any, it stands vacated.
Deeply obliged.
42 AK. Mr. Bora, after that judgment passed by me in Nestor,
Yes, my lord.
why don't you mend your ways?
My lord, now they are acting, my lord, because these debarment orders were passed prior to the order passed by your lordships, my lord.
These were passed in November, Your Lordship. Your Lordship
Prior
had
to-
passed in December.
Prior to the order passed by your lordships, my lord.
Wait, please, Your Lordship. Regarding my lord detailed outlet of Indian Oil Corporation, my lord, in South Karimganj, my LOI was issued in my favor, and my lord, process of NOC's work is going on. And all of a sudden, my lord, they withdraw my LOI, my lord.
Obviously, there has to be some reason.
My lord,
When the provisional LOI has been issued,
my lord.
you have paid 50,000, 100%. Why they have withdrawn must be for some reason. They must have informed you.
No, that is my case, my lord. For withdrawing, my lord, they have to, before withdrawing, they have to give a show cause to me, my lord.
No,
There's a clause, my lord, that has been violated.
Where is
Nothing
the-
has been given. Your lordship kindly see, that is my case, my lord. Because my lord, all the NOC I have received, except my lord, deputy commissioner NOC still waited, my lord, that is within a very short time, it will be happen. It will be, my lord, issued, my lord. Your lordship kindly see, my lord, impugn order.
LOI is cancelled in line with clause 3, 4, 11 and 17 of the LOI. Where is it? Where is the guidelines?
No, that is not guidelines, that is the LOI condition.
Where?
The page 37, my lord.
Huh?
Page 37.
Is 37. See, Indian Oil shall prepare the layout applications for
If-
obtaining. You have
11.
been issued a letter of intent. Final,
No, that is provisional.
not a provisional.
Provisional,
Huh?
provisional,
It's provisional.
my lord.
No. This is final. Letter is merely a letter of intent, is not to be construed as a firm offer of dealership. The dealership will be allotted to you on your complying with the terms and conditions spelled out
My lord.
herein above by issuance of appointment letter along with signing of the standard dealership. So it is just a letter of intent. Now what do you want?
My lord,
Mere issuance of notice.
no, they have cancelled it, my lord.
Obviously, they will
No.
cancel it as you. This is only a letter of intent. No,
But
there's
how they
no.
can, your lordship kindly say their own voucher, my lord, your lordship, voucher, your lordship, the guidelines, they have to follow their own guidelines, my lord.
Eh,
That page to 80, my lord,
Page?
page 80, my lord, and 11 page is 109.
Yeah, this is the brochure I am asking for. Yes, where?
Page, my lord, 80, start from 80, your state, your lordship, go to page 109. The clause 16, 108, and 11 portion is, my lord, 109.
Yes.
Withdrawal of LOI.
In case the LOI holder is unable to provide the land developed facilities within the specified time or due to non-fulfillment of the terms of AR can be withdrawn. Would be issued to the LOI and based on his reply decision to withdraw. So you are saying that no, so cause no.
Nothing, my lord. That is my case.
Who appears for the LOC, IOC?
Make this, my lord. Lordship, I am appearing on behalf of Mr. N. Borua, the standing counsel for IOCL. So Lordship, we are getting instructions from the department and we are ready with our affidavit within 10 days. So on that, within that period, along with our affidavit, we'll place every communication, every document on record. We'll bring on record, my Lordship.
So you leave this court with nothing but to stay the impugned order.
Lordship,
You have to stay it, taking into account that notice was, this court have sought for your instructions on 31/7/2026. 15 days have already gone by. Why, you were only produced to produce instructions? Have you produced the instructions? No.
no, Lordship.
The only way out is to stay it. Did you issue the LOI, show cause notice or not? That's the simple question.
Lordship, we have given him ample scope for.
Did you issue the show cause notice as required in terms with this particular clause?
No, my Lord.
Then we set aside this thing, go ahead, issue a show cause and do it. Matter over. Simple. Where's your senior?
Senior is appearing on before the Honorable Manipur High Court, Lordship.
He has
So,
gone to Manipur.
Lordship, Imphal.
Good. So, we stay, then it is your loss. Issue notice making it returnable on 2nd of November 2026. The K. Gogoi accepts notice on behalf of the respondent number 1. Who appears for 2, 3, 4, 5, and 5?
2, 3, 4, 5, I am appearing before I was.
So and so appears on behalf of the respondent numbers 2, 3, 4, and 5. Mr. MCT appears for respondent number 6. The present petition has been filed by the petitioner alleging violation of clause 16 of the brochure of selection of dealers for rural and regular and rural retail outlet, June 2023, whereby it is mandated that withdrawal of LOI is only permissible after issuance of a show cause notice and taking into consideration the reply. This court duly takes note of that instructions were sought for by this court on 5/8/2026. But the standing counsel of the respondent numbers 2 to 5 have failed to provide any such instructions. The T.J. Mohanta, the learned senior counsel appearing on behalf of the petitioner, submits that if there is no interim directions passed in the present proceedings, there is every likelihood that the respondent authorities shall again tender the retail outlet, isn't it?
Yes, madam.
The retail outlet, and thereby leading to multiplicity of proceedings. So taking into account that in spite of opportunity being granted, no instructions have been placed as to whether the show cause notice have been issued to the petitioner or not, or for that matter, whether there has been a compliance to clause 16 of the brochure. It is the opinion of this court that the petitioner has been able to make out a case, prima facie case, for grant of interim directions. This court also takes note of that in the circumstance any interim order is not passed, there is every likelihood of third-party rights being created as well as multiplicity of proceedings. Accordingly, this court passes the following interim order till the next date. The respondent authorities, more particularly the respondent number 2 to 5, shall not proceed further pursuant to the cancellation, impugned cancellation of the award of the retail, impugned cancellation of the letter of intent of the retail outlet dealership at from Sorgola Motor
Motor stand
Stand to South
South
Karimganj
Karimganj.
Development Block on Sorgola Kaliganj Road, District Karimganj, dated 3/7/2026 till the next.
Deeply.
Yes, Mr. Bora.
May I please, your lordship, my lord, the petitioner quoted highest rate in respect of one market, my lord. And in spite of his highest rate, my lord, the private respondent has been recommended for settlement of the market, my lord, that page 23, my lord, serial number 5, my lord. That private respondent quoted 6,32,700. Whereas the petitioner quoted, my lord, that annexure 4, page 22, 6,66,600.
Which market?
Market
Masbat
is
by-
Masbat Weekly Open Market, page 23, serial number 5, my lord.
He quoted 82 lakhs.
No, my
No,
lord.
no.
Weekly market.
The settled rate 6,32,700.
And how much did you quote?
I quote, my lord, page 22, 6,66,666, my lord.
And you are referring to clause 12 of the notice
13.
inviting tender.
Clause 13, my lord.
13?
Yes, my
Yes.
lord.
That is your case?
Yes, my lord.
I'll obtain instruction. It may be backed by some reason, my lord, why it was not settled with him.
We stay?
Lordship may not. Because
100%
Lordship,
we are staying.
Lordship, 4/8/2026 had already been settled with,
So what?
Lordship, a short date be given, Lordship will obtain
No, how do you
instruction.
take care of clause 13?
Lordship, so it may I read, my lord, once?
Yes.
Clause 13, the competent authority shall make settlement with the highest bidder if all the necessary documents and government revenue are found in order.
Where is the comparative statement?
Comparative statement I have sought for, I have categorically stated, my lord, they have not provided me anything, my lord.
Lordship, then
Because they
thereafter,
are-
your lordship, in case settlement is not made with the highest bidder, the competent authority shall record reasons in writing for the decisions. So I'll obtain instruction on Tuesday, my lord, because tomorrow is a holiday. Lordship, Monday it may not be possible. Tuesday I'll bring instruction. It may not be state, my lord.
But we state. Issue notice making it returnable on 21st of August 2026. And so accepts notice on behalf of the respondent numbers 1, 2, and 3. Give her name. As regards the respondent number 4, the petitioner is directed to effect service by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Pursuant to a tender notice dated 27/5/2026, issued by the council head of the department, Markets and Fair Department, Boroland Territorial Council. The petitioner participated in respect to the settlement pertaining to the Masbat Weekly Open Market. How are the rates fixed? Do you have a similar provision like 48 of the Panchayat rules, although Panchayat does not apply? Because it seems that you have given the 3 rates: existing schedule rate, settlement rate, proposed schedule rate. No, it's not there. Have applied for the had submitted the tender for the Masbat Weekly Open Market. It is the case of the petitioner that the petitioner had quoted an amount of rupees 6,66,666. However, the council head of the department, Boroland Territorial Council, that is the respondent number 2, have granted the approval for settlement of the various markets, including the Masbat weekly open market in favor of the respondent number 4 at an amount of rupees 6,32,700 by the impugned communication dated 29/7/2026. The learned counsel for the petitioner, referring to clause 13 of the tender notice, submitted that it is the highest bidder who has to be granted the contract unless reasons are recorded. It is the further stated case of the petitioner that the petitioner had duly qualifies in all other aspects. I've also heard Ms. B. Bhuya, the learned senior counsel, assisted by so-and-so, appearing on behalf of the respondent numbers 1, 2, and 3, who submitted that clause 13 of the tender notice specifically mentions that the highest bid would be accepted subject to qualifying in the other aspects. The learned senior counsel therefore submitted that she would obtain the necessary instructions in that regard as to why the petitioner's bid, though higher than the respondent number 4, was not approved by the respondent number 2. The learned senior counsel further submitted that a impugned communication was issued on 29/7/2026, and the petitioner has filed a writ petition on 10/8/2026, and therefore submitted that in the circumstance the contract has already been awarded to the respondent number 4. This court may not pass any interim directions. This court had given an anxious consideration to the respective submissions, and it is the opinion of this court, on the basis of the materials placed before this court, that the petitioner has been able to make out a prima facie case for passing off, have been able to make out a case for passing off interim directions. Accordingly, this court passes the following interim directions till the next date. The respondent numbers 1, 2, and 3 are jointly and severely directed till the next date not to award the Masbat weekly open market to the respondent number 4 if not already awarded. Number 2. In the circumstance, the respondent number 4 had already been awarded the Masbat weekly open market on the basis of the impugned communication dated 29/7/2026. This court shall consider the above directions in clause 1 shall not apply. and this court shall consider as to whether there would be a requirement of passing any interim directions on the next date.
Obliged, my lord.
May I
What is
continue?
this?
My lord, matter pertains to, my lord, outstanding bill, my lord, for construction of multi-storied supermarket at Kokrajhar, my lord.
When did you do it?
My lord, it was done, my lord, before, my lord, 2021, my lord. 95% work has been already completed, my lord. Page 41, this is their documents, my lord.
Then
And first installment has been given, my lord. 1 crore something, my lord. The total costing, my lord, the 3 crores 61 lakhs 94,008, out of which, my lord,
এটা issue notice কৰি দিব, returnable 16th November. তলত এটা line বাকি লেখা হৈছে, maintainability or repetition on the question of delay in latches is kept open.
obliged, my lord.
To pay non-payment. What is this?
My lord, the petition was running a private fish market, my lord, under revenue of Barpata, my lord. In the month of May 2026, my lord, the official of Barpata come to the market and stop their selling, my lord. Actually, this is a private market, my lord. So he has the right to market, running the market, my lord. Some vendors he has allowed, my lord.
Not to disturb the petitioner in running the daily fish market on her private land.
Yes, lordship.
And also issue, where is this land?
Land is, my lord, Bhavanapur Road in village Sodiapur under Barpata Revenue Circle,
Where?
my lord.
Does it fall within the Gaon Panchayat?
No, my lord, municipal area, man. Municipal area.
Huh?
Municipal area, man.
Municipality?
Yes, lordship. For the last 3 years, he has been.
How do I know it is municipality? Not the Gaon Panchayat has nothing to do.
I have submitted representation, my lord.
Who is creating trouble?
Municipality, my lord.
Huh?
Municipality, my lord.
Why?
He has running the market, my lord, on his own private land, my lord.
Huh?
He has also paying 20 rupees per month, my lord.
Why you are paying?
Tax, my lord.
Paying for what? A daily fish market on my Patta land in ward number 14. Under Barpeta Municipal Board, I am in need of no objection to permanently run the same market. Then, meaning thereby you don't have. The issue notice. Issue notice. Is that okay? Is it a good case for issuance of notice?
That also, lordship.
Huh?
No cause of action arises, lordship.
My lord,
Very difficult.
my lord, they have also taken over my weight and measurement and also take 70,000 rupees, my lord.
Where is your FIR?
I have not meant, but submitted application, my lord.
Submitted a representation to the effect that look here, to the chairman, that look here, how are you taking? Okay.
Well,
Oh, submit representation. And then come over if you will meet a case out there. Very difficult.
my lord, notice issued, my lord.
No notice. Some notice not made out. Not with a better case. You have not even submitted a representation also. You are paying some 7 rupees, 20 rupees
Well,
or something to the
I
effect.
have submitted.
Toll for what? Why you are paying the toll of 70 rupees? Tell me. Where is your representation? You are asking for a mandamus.
My lord, I mean, paste.
You are not asking that kindly give me the permanent license in the prayer.
Yes, lordship.
What is your prayer?
My lord, in the.
What is your
Yes,
prayer?
yes,
Not to disturb and to issue necessary license or NOC for running the market.
Market, my
So you admit there is no NOC and then also you are doing it.
My lord, this is a private market, my lord.
So therefore, why you are asking for NOC?
Private land, my lord.
Why you are asking for NOC?
Because
My
they,
question is,
yeah,
why you are
because,
asking for
well,
NOC?
because they are disturbing me, my lord.
Huh?
They are disturbing me.
And what is this document? Annex 3?
Annex 3,
Where is the receipt?
Nothing is there also.
they refused to accept it, my lord.
Huh?
He submitted, my lord, but they have received, refused to accept it, my lord.
What? So they have not even taken it. Submit your representation and come over. I can give you that direction.
Yes, lordship.
Submit a representation, they will consider, that's it. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. K. Gogoi appears on behalf of the respondent numbers 1 and 2 and 4
And 5 also.
and 5. The present petition has been filed by the petitioner, taking directions upon the respondent authority not to disturb the petitioner in running the daily fish market on her private land, and also to issue necessary license or NOC for running the market. This court have duly perused the materials on record. And from the materials on record, this court is of the opinion that this is not a fit case for being entertained. So there is also no representation which has been submitted by the petitioner. So under such circumstances, the question of when there is no demand of justice, the question of issuance of a writ in the nature of mandamus also does not arise. Considering the above, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude the petitioner to submit a representation to the respondent number 4 and 5, to respondent number 3 and 4, if so advised. And in the circumstance such representation is submitted, the respondent number 3 and 4 shall duly consider the same.
Obliged, lord.
My lord, the petitioner here has completed a railway project, my lord. My lord, after completion of the work, he met a fatal accident, my lord. And my lord, he submitted an NOC because, my lord, under the railway contract, my lord, after completion of the work, an NOC has to be furnished by the contractor so that he can get the security deposit and all this thing. Now, my lord, there was a pending PVC, price escalation bill, PVC 2. The railway are saying, since you have submitted an NOC, therefore your PVC bill cannot be considered. Now, my lord, my only submission is that let the railway consider my PVC bill without taking into account the no objection certificate which I have, my lord, which I have furnished, my lord, after execution of the work, my lord. If I am entitled, otherwise,
What does the NOC mean?
my lord, after completion of the work, when the final bill is are paid, the railway, they ask an NOC, no dues, no claim certificate, that all your dues have been settled and everything. Now they submit, and if they do not submit an NOC, my lord, they will not get the security deposit at
When did you submit the NOC?
2018, my lord.
And you have woken up in 2025?
My lord, I can say something, my lord. This
Don't
man
say
has
anything.
literally
Don't say
survived
anything.
death. My lord, this man has literally survived death.
I can't help you. I don't have anything to that. If you have anything, civil court, you have kind judges, not me. The first is you have submitted your NOC in 2018 after getting all the dues, you get it. And then in 2025, you wake up and say that, look here, I forget about the NOC. Give me the PVC claim.
Yeah, but they admit
Fantastic.
it. In 25, they admit it.
So what?
On 25, they admit it that the claim is checked and it is correct. They admit it in 25. Because there was a continuous,
So
even the
with that
railway department.
with that admission, go to the civil court. The good judge is there, not this court.
My lord, my only prayer is that, my lord,
Dismissal?
my lord, My,
Dismissal?
my only prayer is that, my lord, if the PBC,
Mr. Counsel, we apply the judgment of P.K. Ramaya versus ONGC, isn't it? 1994 squarely applies. So we dismiss him so that he even can't go even to the civil court. Say judgment to Diok, P.K. Ramaya. Just now. So that the agony of this person for fighting litigation no longer remains. Withdraw, go to the civil court, better, not here. Which one? Dismissal?
the later one.
Mr. M. Vishwas, the counsel appearing on behalf of the petitioner, submits that taking into account that there are questions which, taking into account that the instant proceedings may involve various disputed questions of facts, the petitioner would not like to pursue the present proceeding and would avail remedies before the competent court of civil jurisdiction. So taking into account the above, the instant writ petition stands closed on withdrawal. So the withdrawal of the instant writ petition shall not prejudice or preclude the petitioner to avail remedies before the competent court of civil jurisdiction if so permissible under.
My lord, if there is any rider regarding limitation. my lord,
What?
Limitation, my lord, because 2018 money claim, it may, if something falls from your lordship, which may save this man. my lord. To
Mr.
that extent.
Vishwas, honestly, do you think that that type of prayer can be made? Does this court have the power to extend the limitation?
My lord, some rider.
You forget that this is a Gauhati High Court. This is not the parliament. Parliament is there. Go to Delhi, ask that these type of things, kindly insert a section. Otherwise, take the benefit of 19. You know very well. I can't.
I'm deeply aware.
Look, my presence may be recorded.
You didn't say anything.
Yes.
Yes, what is this?
Lordship,
You are hell bent upon the PhD department, madam.
what to do, Lordship?
Yes.
They give me
All
such a
everywhere the PhD
stepmotherly
department comes
treatment.
into the picture.
Such stepmotherly
Seems,
treatment.
it's the same.
Same company, Lordship gives.
Now, what has happened now?
They are saying that we have not complied with the order, your
Huh?
lordship. Yes, the prayer is that we have not complied with the order.
They have not complied.
Yes, that's
Is
what
this
they
a contempt petition?
No, writ petition.
I file a writ because contempt, I'll punish them. But writ, I can go for implementation order by a writ.
What implementation? This is not for implementation.
Order which Lordship passed. Lordship 2000.
I passed these directions. If they have not complied with, then you know what is to be done.
Lordship, I can file a contempt also, but contempt will not serve.
File a contempt is that for non-compliance. This is not the case.
No, but implementation, let them consider Lordship's direction. Lordship will pass a direction and they'll sit. Lordship, because 2007 Supreme Court clearly says for implementation of the order, which is passed by the court, I
Have you not passed that order?
Lordship,
I've asked you to pass an order in this case.
consider and pass an order. Last part.
You
Yes.
observe that in the circumstance, the parties to the instance are not in agreement. Have you not decided what is the amount?
That I have to take and check whether they've decided or not, because nothing communications coming have
Huh?
come from them side, their side, your lordship. Whether they have decided on this amount or not, and speaking on this past, nothing has intimated to us till now.
Now, we have set aside these MOUs
Yes, Lord.
and the petitioner in the three petition being so-and-so registered under so-and-so would be entitled. The above declaration and so shall not reopen any claims of pertaining to the so-and-so. The petitioner in the three petition are given the liberty to carry out the exercise of calculating, and they have submitted that document.
Yes, Lordship.
Where?
Page 96.
So they have given this
They're
document.
given
Now,
this document.
when was this given?
Lordship for
412.
412.
And there was a direction to
Disposes of within 90 days.
90 days. Then,
Then they did nothing.
chalo, we dismiss your petition. Because this is not a court. It's not for contempt.
No,
Contempt, read for another contempt.
Lordship, there is a decision of the court, Supreme Court, which says I,
Where?
2007.
Supreme Court. Very well. Go to the division bench. Division bench, then to Supreme Court. Show it. They will immediately pass on
No,
order.
Lordship, this something.
Absolutely no, madam. I'm going to dismiss it. This court is not going to pass any further directions. Sorry. I'm
No,
not
ask,
going to.
Lordship will ask them to
Now,
come.
this is the result why it has happened. The result why this long judgment had to be passed is on account of petition after petition after petition being filed in those proceedings. First you file a petition, then a contempt, then another petition, then contempt, and in contempt various documents they pay something, then another petition where the court passes an order, make payment, and thereupon so and so.
They don't comply, Lordship. Now, where do I go, Lordship, for implementation of this direction?
Contempt is there, na?
I can file a contempt. But
This court is not going to issue notice in this. Sorry,
no, let
dismiss
no, Lordship, just next
with
week.
cost.
Oh, no, Lordship.
Cost?
No,
No, it is given with due advice of Madam M. Hazarika,
Lordship,
who is a
can we-
senior
if I
counsel
can
with
just
great repute and has given such type of advice. Without your
Yeah,
advice, they may not have done
Lordship,
it. Unless Mr. Khan have asked you to do it in this manner, that whatever may be, do the matter, stand over in the court will issue a notice.
Lordship, 2007, one SCC, Lordship is there.
What does it say?
It says fresh writ petition on cause of action. If subsequent cause of action arises in implementation of the judgment, a fresh writ may lie. So they have not implemented. So fresh, this has given me a fresh cause. Then there's one more. Yes, there's one more, Lordship. Non-implementation has given me another. Which paragraph? Hold on. Lordship, paragraph 32, there's another section, paragraph 32. We have the considered opinion once a direction is issued by a competent. It has to be.
Madam, I have stopped reading from head notes.
No, I'm reading from the inside, Lordship.
Let's see where.
Paragraph, this
The
paragraph.
judgment
27.
as is well known
23,
is
paragraph
not to be
23,
read so and so.
First one, paragraph 23.
Paragraph subsequent. There's no quarrel. If a subsequent cause of action arises, it's a different thing. Just for example, tomorrow they reject anything. When I have granted you the leave to that effect, now there was a direction asked them to decide within 90 days. If they have not done it, file a contempt, we'll look into it.
And Lordship, just one more, Lordship. I'm placing 2007, 7 SCC. We are of the page paragraph 23. 32, sorry. We have the considered opinion that once a direction is issued by a competent court, it has to be obeyed and implemented without any reservation. If the order passed by the court of law is not complied with or is ignored, there will be an end to the rule of law. If a party against whom such a order
Good.
is
We dismiss, taking into account, relying on these judgments, we dismiss your petition. Or
Lordship will
Ms.
not
M.
dismiss it.
Hazarika. No, madam.
Lordship,
M.
where do I-
No, I give you the liberty also to file a contempt.
This can be converted into a contempt.
Absolutely no. That is 215. This is 226. You can't convert a proceeding. How? Now tell me,
Yes,
can the contempt be against the chief engineer?
can be only against it.
Yeah.
But Lordship, this implementation, do I get it implemented? That is my question. They will just.
Madam.
Even if I file contempt, they're not bothered.
Madam, the fact remains that I am not here to advise
Then Lordship, let it
what
come
is
up
there
on
to
this.
be done.
Lordship,
You
let it
file
come
a
up-
contempt, madam, we'll look into it. And if you file a contempt, if I am taking it up, I will ensure that it is being complied with.
Lordship, let it
I am
come
not
up-
so good in a writ petition, but I am very good in a contempt. I know how to get it done.
Lordship, let it come up on Wednesday.
We dismiss right away now.
Wednesday.
There cannot be two things.
Lordship, Wednesday.
Withdraw.
I'll withdraw and file a contempt.
Yes. Very well.
Fine, Lordship, I'll withdraw and file a contempt.
Change the names. Only thing is, within 90 days, they were required.
Required.
And in these cases, I even know, don't issue notice. I get it complied before that. Don't worry. Sometimes I know how to get it complied. So therefore, I may not be good in writ petition, but very good in contempt.
I'm within time.
Why there I am sitting?
No, they're smiling at me saying, "এক বছর আছে."
Ms. M. Hazarika, the learned senior counsel, assisted by Mr. D. Khan. Submits that the instant that the petitioner is compelled to approach this court on account of the non-implementation of the directions passed by this court. In the judgment and order dated 13/11/2025 passed in WPC number 5273/2023, wherein the Special Chief Secretary to the Government of Assam PHED was directed to carry out the necessary verification on the claims submitted by the petitioner and thereupon make payment to the petitioner their dues as per the verification carried out by the respondents. The learned senior counsel submitted that this exercise was to be completed within a period of 90 days from the date of submission of the respective claims by the petitioner. In pursuance to that, the petitioner on 4/12/2025 not only submitted a copy of the certified copy of the judgment and order dated 13/11/2025 to the Special Chief Secretary, Government of Assam, PHE Department, but also provided the calculations as was directed in terms with clause Roman, in terms with paragraph 85 Roman 7. It is the opinion of this court that if the order, judgment and order passed by this court dated so and so, passed in WPC number so and so, have not been complied with, it is a case where the respondents in the personal capacity have disregarded, have committed and willful and have willfully disregarded the directions passed by this court. Have acted in willful and deliberate violation to the directions passed by this court. Under such circumstances, as the willful and deliberate violation can be only qua a person and not the office, it is the opinion of this court that a writ petition cannot be maintained on account of for implementation, for the purpose of implementation of the writ petition, implementation of the judgment and order passed by this court, dated so and so. Ms. M. Hazarika, the learned counsel, senior counsel, submits that without prejudice to the petitioner's claim, the petitioner may be permitted to withdraw the instant writ petition. And if so advised, prefer an application for initiation of contempt proceedings against the respondents in their personal capacity. Taking into account the above, the writ petition therefore stands closed on withdrawal. The withdrawal of the instant writ petition, however, shall not preclude or prejudice the petitioner to avail remedies under the Contempt of Court Act 1971, read with Article 215 of the Constitution of India.
Obliged, Lordship.
Obliged.
Wait, please, your lordship.
What is this?
My lord, this is an order, my lord, passed by the London Honorable Labour Court, my lord.
Hey,
Recently, my lord-
Mr. Barbuzari, give your names. Ask Mr. R.R. Gogoi also to give your names.
2015, my lord.
What is this
Termination of-
award?
My lord, initially, my lord, an award was passed that my lordship will find at page 47, an application was filed, my lord. The prayer portion, my lordship, may kindly peruse page 55.
Oh, you are challenging which one?
I am challenging, my lord. This order was set aside by the Honorable Court, my lord.
Which one?
This order, my lord, that subsequently order was passed, that page number 82, my lord. '82, relevant part 84, last para, my lord. In the result, the management is directed to pay full back wages, including retirement benefit, to be paid from the date of dismissal within 3 months from the date of this award. Then this was set aside. My lordship may kindly come to page number 90. 85 is the order, my lord, of this honorable court, my lord. 85, annexure 8. And relevant part, page number 90, my lord, para 9.
Directed to pay full back wages, including return to be paid from the date of dismissal within 3 months from the date of the award.
My
Okay,
lordship.
Then
Then page 85, my lord, the said award was
what did
challenged,
I
my
do?
lord.
Taking into the award suffers from perversity on
Based-
law for reasons aforesaid, further as the petitioner's entitlement to the claims made in his application is required to be adjudicated, this court directs the presiding to decide afresh the said proceeding. In doing so, the presiding officer of the year shall permit the petitioner herein, which is the management of so and so, to file their written statement. On filing the written statement, so there
Page
was an
90
ex parte of
para, my lord, but my
So
lord
that
has
I
made
set
some
aside.
findings.
Huh?
Para 9, my lordship may kindly
The
peruse for a
petitioner
moment.
herein has already deposited.
Para 9,
9,
page 90, my lord.
9, why should I look into para 9?
My lord, this is the, my lord, reason why the order was set aside.
On application can be seen from the fact that the learned labor court had applied so and so of the Iman, although the said provision is a state amendment applicable only to the state of Gujarat. Then
Now, my lord, on the same line, my lord,
Never took note of the wage board, so and so, so and so, so and so. Then
regarding
what has happened
compensation.
then?
Now, my lord, 136, my lord. 136 is the award passed, my lord.
Ah,
Fresh award, my lord. 136.
what happened? What the court have done?
136 is the fresh award, my lord.
Since
Relevant
it has
portion is
already been held
141.
that a workman has been illegally trenched from his service, and since he is not praying for reinstatement but for back wages, in the result, the back management is directed to pay full back wages from the date of his termination within 2 months from the date of the passing of the award. Management is also directed to release the dues of including areas, gratuity, and earned leave within 2 months from the year. Management is directed to pay compensation of 1 lakh towards the grant for illegal termination.
So, in the original challenge, my lord,
What is the scope of the year?
25, my lord, that is for state amendment, my lordship has
Huh?
already observed. 25 under the provision, my lord, 25 ZA, it's an state amendment. That is what my lordship has observed at page 90, para 9, earlier, my lord. 7th line, my lord. The non-application of mine can be seen from the facts that the Learned Labor Court can apply section 25 ZA of the Industrial Dispute Act 1947, although the said provision is a state amendment applicable only to the state of Gujarat. And apart from that, my lord, no date has been finalized.
So there was no valid inquiry.
My lordship.
Very much, many as per we have the issuance of the provisions of the industrial standing law. In forward of the, let us now see whether the work. Had admitted categorically both is evidence. How many workmen there?
One, my lord. He's an advocate, my lord.
Huh?
He's an advocate, my lord.
Who?
He was the workman, my lord,
This is his name.
by profession.
FZ
First,
Ahmed, FZ
My-
Mazumdar.
my lordship,
Oh, he is it.
my lordship.
Eh? So there is a direct of paying full back wages
My lordship,
from,
not specified, my lord.
for that he is therefore filing a
Combination.
33C.
My lordship,
He is filing a 33C is because of that.
my lordship.
Then you are contesting there.
Yes, my lord, that,
You want to stay on that proceedings.
but my lord, original order, my lord, impugn order, my lord, if we get a stay, my lord, then my lord, that will do, my lord.
Obviously,
Because-
I'm not going to stay there. We will hear other side.
My lordship.
Let 33C be continued.
Because 33C, my lord, that, it has been concluded, my lord,
Order passed.
passed, my lord,
Where?
labor court, my lord.
Where?
It
Where is
is-
the order?
My lord, today they have initiated one proceeding before the CGM for, my lord, implementation of that order. That matter is fixed today, my lord.
Where is the order of 33C?
That we don't have, my lord.
How is it possible that the 33C cannot happen without giving you a notice?
Notice was given, my lord.
Then you
Before-
did not participate.
Before 33C, my lord, we filed this petition.
No,
And then, my
whether-
lord,
No,
subsequent to, my
no,
lord,
my question is, this is an award passed on 24.
my lordship.
And you are
And we-
pushing this
we-
for today.
No, my lord, we filed a writ petition.
Huh?
Subsequently, my lord, the proceeding was going on. And we filed a writ petition, but we had to withdraw, my lord, due to certain defects.
What is
And
the
then-
defect?
My lord, it was the impugn order, my lord. It was inadvertently some other order was annexed, my lord. There are two orders in this.
But you
particular-
filed that writ petition in the year 2026, after 2 years, then
20
also.
25, my lord.
26, WPC number 3612, oblique
lordship.
26.
Because, my lord, 33 proceeding by that time they have initiated.
So
And
why didn't you participate there?
we filed a written statement, my lord, there.
Let's
But-
issue a notice, merely notice, nothing stay. Mr. Gogoi, case made out?
My lord, 2019,
Notice this.
my lordship, may I kindly see,
No case is made out.
2019, I was asked to pay full back wages. Then the impugn order, again, my lord, I am asked to pay full back wages, my lord. That, my lord, there is no specific.
Full back
timeline.
wages till the date of termination.
No, my lord.
See, the
That-
the first is,
After that,
the
my lord,
moment he has not asked for,
lordship.
he says he does not want. When was he terminated?
He was 2015.
So he was 2015.
My lord.
So the proceedings initiated on a particular date. So after 1 year, he has filed a 2A.
No, my lord. He approached the additional assistant commissioner, my lord.
We are not
But-
concerned with that. We are concerned with 2A.
Okay, my lord. Yes, my lordship. Then 2019, the order was passed. And 2024, again, my lord, same order was passed, my lord.
But you have not challenged the 33C order.
That, my lord,
Without the challenge, why should I challenge the state award?
because till now, my lord, after filing of
You
this
want to
case,
again
only,
withdraw?
my lord,
Second time withdraw.
I will take,
But it can't be given so many times.
I'll take instruction, my lord, I'll file an additional affidavit, my lord.
The counsel appearing on behalf of the petitioner submits that certain orders have been passed in the application under section 33C of the Industrial Disputes Act 1947. And he would obtain instructions and if necessary, place it on record by filing an additional affidavit. This is how much time?
1 week, my lord,
1 week.
my lord.
Is this matter on 26th of August 2026? In the meantime, the affidavit be filed.
Deeply obliged, my lord.
Yes.
May it please your lordship, on the
What is
last,
this additional affidavit business?
your lordship, after the filing of this writ petition,
Hmm.
clarification was given to me on 7th of August.
Hmm.
And other two documents are there which I brought in on record by this additional affidavit on that day, your lordship.
What are these?
Your lordship, the first document is the application, the representation I have filed it, your lordship. The representation I have annexed it with the writ petition also, but it was not in full, your lordship. Therefore, the complete set of representation was brought on by this additional affidavit. And the reply which they have given it to me. And thereafter, after the filing of the writ petitions, they have again submitted me a reply on 7th.
So you don't have slope. You have the slope,
I have the slope protection experience.
but you don't have the,
Your lordship, may I just produce the drawings if your lordships, on that day, your lordship has sought for it?
what drawings?
The drawings of which works, the experience I have, your lordship.
Now, what is this?
These are the slope protection. Your lordship, I have the experience of the slope protection works that is admitted on record, your lordship. The two things which they are saying is that rockfall barrier. These are the rockfall barriers, your lordship.
How? No, this can't be rockfall.
Your lordship, what I'm trying to say
Rockfall
is,
barriers are different.
yes, your lordship, that I have annexed with in my annexure 12, your lordship. This is the work experience I have, your lordship,
I
wire
can't look,
machine.
You had filed an additional affidavit also, you have not enclosed this. Why should I look into all these papers? You just put it across the, yeah.
Your lordship, this is after the filing of the additional affidavit, I got it, your lordship. I can bring it on record if your lordship gives me one
Now,
day time.
my question is,
Yes, your lordship.
I'm not saying Mr. R. Sinha has made a fault. I'm saying your client has made a fault. To place to you all the documents,
Yes, your lordship.
isn't it? And then only you should file it. Now, if he has not placed the materials, then what can I do?
Your lordship, one thing I have stated it very categorically in page 152. The
Hmm.
slope protection work experience I have, which I have worked with NHIDCL, your lordship.
No, you don't have that one. What do you call the rock fall?
Your lordship, the rockfall barrier is an item, is an instrument, is a raw material that I need to procure and I need to install.
No, it has to be fit. Let's see, again see the term,
Your
where
lordship
the
will kindly
term,
come to page 191.
where the term,
Page one, the term is at page 75, your lordship.
yeah. For the purpose of project shall be considered to be completed if more than 90% of the value, isn't it?
Yes,
No.
your lordship.
Which one? Ah,
Page 52, your lordship.
no, which you are referring to which one?
Page 75, your lordship.
Page 75, which one?
Down below. See, slope stabilization / restoration projects.
No, you referred to another clause somewhere earlier. This is being divided. This is another thing. There used to be another thing you
Yes, your
referred to
lordship.
last occasion, no?
Yes, your lordship. That is at page 49. No, sorry, your lordship. It's a page 52.
Look protection. Description, reading process.
If your lordship comes to page 52, the work is given there, your lordship. Slope stabilization measures at kilometers such and such on hillside on road Balipara, Sorduar, Tawang under 91 cc 14 BRTF of Vartak in West Kameng district of Arunachal Pradesh. That is the basic work, slope protection, your lordship. Now they have the next page, fifth page.
No, where is
52.
the terms are required? What are the, you require one job of something, where is that particular clause?
Page 53, your lordship, description.
Yes, two similar completed works costing not less than amount equivalent to 25% of the estimated cost here. The completed work shall consist of steel wire mesh, rockfall barrier, and articulating block mattress. So that is 7
Yes, your lordship.
crores each,
Yes, your lordship.
or one work wherein steel wire mesh, rockfall barrier, and articulating block mattress.
Right, your lordship.
Now, in the additional affidavit which you have filed, they give a clear aspect in their reply
Yes,
to
your
your
lordship.
representation dated 7th of August 2026 at page 269.
Yes, your lordship.
Your representation has been examined with reference to the so-and-so and the two so-and-so evaluated every bid strictly in accordance the prescribed similar work was solely on the basis of the bid and document. Experience survey furnished by your firm established execution of slope protection work. However, the bid documents did not establish the stipulated experience relating to what is this ETAG 0, so is certified rock fall barrier with early warning system. Number 2, geotextile articulating concrete block mattress of original manufacturer, both of which were mandatory similar works requirements under the RFP. To so-and-so have been carefully, one cannot be read in isolation, and so-and-so requires procuring entity to determine whether the bidders satisfy the prescribed eligibility criteria, and eligibility provides that the tenderers not meeting the RIA shall be rejected. So-and-so is an enabling provision which permits at the discretion of the proposal clarification of minor ambiguities, and so-and-so does not fall within the ambit of the seeking shortfall documents. This was not a case where an otherwise alia had omitted to upload an existing completion certificate or similar historical document. Rather, the bid document themselves does not demonstrate compliance with the mandatory similar work prescribed in so-and-so. The planner would have amounted to allowing a bidder to cure an essential qualification criteria so and so. The evaluation criteria was uniformly applied to all bidders. There was neither here. So, no case.
Your lordship.
Even without speaking a word, we can dismiss.
Page 195, your lordship, may I draw your lordship's kind attention for a moment?
Any 195.
191, your lordship.
Yes, what is this?
This is rockfall barrier, your lordship.
Ah,
These are the photographs I have annexed with the writ petitions. These are the materials, your lordship, just like any other raw materials. I need to purchase it and install it.
no. That is not the question. My question is whether you have an experience certificate to that effect that you have carried out these works. That's the only question. They are not going to go and see what is there because it is for this court. I am not an expertise to say that this is a rockfall area, this is a slope protection. These are specialized technicians or the experts out there who feel that you have not submitted that document. That is the specific here. And this is an essential condition which cannot be then supplied by subsequent documents in terms with clause 6.3.5. No case.
Your lordship, page 152, I have submitted my experience certificate. Page 152, I have submitted it. I have categorically stated what works I have done.
152.
This is the work I
Is
have
the
done under NIGDCL,
Construction
Your
of
Lordship.
upgradation of PIA. What is the work done?
Your Lordship will come to page thereafter 153.
Ah.
Serial number 1, protection works, that is retaining wall, toe wall, gabion wall and such wall. Number 1A, retaining wall with surface drainage pipes. Then the next, with the use of geotextile gabion structure. Then number 2, slope protection wall, hillside, wire mesh with bioengineering. Then number A, slope protection work, hillside, high tensile rope net system with high tensile steel, wire mesh, hydroseeding with bioengineering, Your Lordship. The photographs I have given Your Lordship just now. So the most important fact is the work experience of the slope protection, which admittedly I have, Your Lordship.
No. The completed work shall consist of steel wire mesh.
Yes.
It is not here. Let us see, I think they will be, because they have already done it here.
No, wire mesh they have sought, Your Lordship. Let us read
Huh?
once again, page 52.
No, that is okay, but there will be other documents what is required. Class 1 here means the
Which?
supplier, so and so. There is the term event, notice, general bidding, the bidder should submit. Just so and so,
Page 53, if you read once again, Your Lordship.
because not page, we cannot go on that, we have to look into the others.
Steel wire mesh they have sought it, Your Lordship.
Okay. Where is the expend, 2.2.1.
Yes, Your Lordship.
For determining the eligibility, the following, the buyer shall be a single entity or a group of companies, the bidders in natural person, the bidders shall have conflict of interest, then bidders so and so constituent, so and so any bidder from a country which shares a land border, bidders so and so, either in case of a partnership, certificate regarding compliance, validity, peak capacity, maximum so and so, technical capacity. Whatever the Iman they'll have over 5 years in the case of standalone specialized projects, so and so, so and so, so and so, so and so, 5 years. Estimated normal highway standalone marginalized area for normal highways, non-similar works costing not shall be considered to be completed if more than 90%.
In fact, at page 266, they have categorically stated that these two experience I don't have. I mean, these two materials I don't have.
Or in the case of so and so have completed at least one or two similar SRW, means slope restoration. What is SRW? Project having design, supply and installation of high tensile steel wire mesh
Yes, Your Lord.
of tensile strength minimum 150 so and so certified rock barrier with early warning system and so and so, so and so, so and so. And in the past 7 financial years, the bid due date or till the bid due date, and also the cost of such similar shall be at least of 25% of the estimate, one of 35%. So this is the requirement.
Yes,
Now,
Your-
where's your rejection?
Your Lordship will come to page 266, Your Lordship.
Page
266 of the additional affidavit. Now, Your Lordship will see design, supply and installation of high tensile steel wire mesh of tensile strength, minimum 150 kN such and such. Yes, meeting criteria. Number 2, ETAZ certified rockfall barrier with early warning system, not meeting criteria. Geotextile articulating concrete block matrices of original manufacturers, not meeting criteria. These are the two things which I need to purchase it, just like any other raw materials.
Oh, that is the ground.
Yes. And
Dismissed. No case.
and my experience
Oh.
is at page 152, Your Lordship.
Because this is you need to purchase. My question is, your experience is there or not in respect to this? ETAZ certified rockfall barrier with early warning system. Do you have a certificate to that effect?
No, Your Lordship.
Thanks. Unless you show that that certificate is not required. I understand. I understand your what your submission. Your submission is, look here, these are the things, we have done many things like this. This is a simple thing. We'll purchase and put it.
Place it, yes, install it.
That's your thing.
Yes, Your
But
Lordship.
the question is, do you have an experience certificate for that? My question is this.
In case of slope protection,
No.
slope protection I have.
No, this ETAG 02 certified rockfall barrier with early warnings. We have an experience of that. We are not matter ends there, huh? Heard Mr. R. Sinha, the council, because issuance of notice would not help you. We may very well go to division bench.
No,
we
I
may-
don't go. I don't.
But otherwise it makes no sense. If I issue a notice, no, without granting a stay, it is just the matter is pending. Heard Mr. R. Sinha, the learned counsel, appearing on behalf of the petitioner. Ms. A. Gayan, the learned CGC, appears on behalf of the respondent numbers
1 to 5, my lord.
1 to 5. The present writ petition has been filed challenging the rejection of the petitioner's technical bid by the communication dated 1/8/2026.
No, Your Lordship, it is, I'm sorry, the report is at page 148, 29/7/2026.
A
140.
rejection of the petitioner's technical bid
It was uploaded in
One-
the,
as uploaded, the information of which was uploaded on 29/7/2026.
correct, Your Lordship.
And subsequently informed to the petitioner by the communication dated 1/8/2026. The brief facts which led to the filing of the present writ petition is that a request for proposal for slope stabilization measures at kilometer 114.200 and 120.500 on hillside on road Balipara de Sorduar, de Stawang under 91 RCC /14 BRTF of P Vartak in West Kemang district of Arunachal Pradesh was issued by the Border Road Organization on engineering, procurement and construction (EPC mode) by the notice inviting e-tender dated 9th of May 2026. In terms with the said notice inviting bid, the list of eligibility and qualification requirement of the bidders were briefly stated. First, briefly stated in the table mentioned in the said notice inviting bid. Insofar as the threshold technical capacity, the criteria was mentioned as rupees 22.98 crores with specific reference to clause 2.2.2.2 bracket Roman 1 of
Page 71.
As detailed out in section 1 of the notice inviting bid. Insofar as the technical capacity insofar as regards the technical capacity, the description was mentioned with specific reference to the criteria and the request for proposal clause number 2.2.2.2 bracket Roman 2. Full stop. Taking into account the relevance for the sake of convenience, this court finds it pertinent to reproduce the table of the notice inviting bid, more particularly at serial number 3, which is at page 53 of the writ petition. 53, খালি এইখন, বাকিবোৰ নালাগে, খালি ওপৰত dot dot দি ওপৰত। Full stop. This court also finds it relevant to take note of clause 2.2.2.2 Roman 3 C, which is the slope stabilization oblique restoration projects, as the same has a vital bearing on the present dispute. The said clause is reproduced herein under page 75 of us. The petitioner, along with various bidders, submitted their bids pursuant to the request for proposal. In the technical evaluation so carried out, amongst the 5 bidders, the petitioner, along with the bids of 2 others, along with another, were rejected, and bids of 3 other parties were accepted. The petitioner, upon coming to learn about the rejection, submitted a representation on 29/7/2026 itself. And taking into account that in spite of the said representation, the respondents were proceeding with the bid process, the tender evaluation process, the petitioner approached this court by filing the present writ petition on 7/8/2026. In the meantime, the petitioner would get hold of the rejection of the petitioner, the communication by which the petitioner was informed as to why the petitioner's bid was technically rejected.
I'll just, I'm sorry to interrupt. On 1/7/2026, they've informed me the rejection.
Then why didn't you enclose it earlier?
I have enclosed it, Your Lordship.
No, page 266.
No, Your Lordship.
Why have you filed it by way of an additional affidavit? Obviously, you have not enclosed.
Your Lordship, that, I'm sorry, Your Lordship, that I have missed it, Your Lordship. But I have made a statement to that effect, why it was rejected on 1/7/2026. I've made a statement, but I could not annex it. So by an additional affidavit, I've annexed it. And more importantly, on 7th also, they have submitted me an application, further
That's good.
clarifying.
What did I write? So, illustrate. By the communication dated 1/8/2026, the petitioner was informed why the petitioner's bid was technically rejected. The technical bid was rejected. This document dated 1/8/2026 was brought on record by the petitioner subsequently by filing an additional affidavit. From a perusal of the said document, it is apparent that the petitioner, in terms with clause 2.2.2.3 to 2.2.2.2 Roman 3C, though had submitted similar work experience pertaining to design, supply and installation of high tensile steel wire mesh of tensile strength minimum 150 kN capital oblique M, but the petitioner did not submit work experience pertaining to ETAG, all caps, 027/EAD certified rockfall barrier with early warning system, as well as geotextile articulating concrete block mattress of original manufacturer. At this stage, this court also finds it relevant to take note of the representation which was submitted by the petitioner on 29/7/2026, wherein the petitioner at paragraph number 7 paragraph 6 and 7 submitted that the petitioner had duly submitted all such documents, but however, if it was felt that the certain documents in respect to the technical bit of the petitioner was found inadequate, the petitioner should be granted an opportunity to submit the shortfall documents in terms with clause 6.3.5. The representation of the petitioner was rejected by the respondents by the communication dated 7/8/2026, holding inter alia that the bid documents so submitted did not establish the stipulated experience relating to number 1, ETAG 027/EAD certified rockfall barrier with early warning system, and Roman 2, geotextile articulating concrete block mattress of the original manufacturer, comma, both of which were mandatory, similar work requirements under the RFP. It was further mentioned in the rejection of the representation that the question of invoking clause 6.3.5 did not arise, that inasmuch as these documents, these experience certificates would not come within the ambit of shortfall documents, inasmuch as these documents were requisite and essential to be submitted at the time of submission of the bid. It was further mentioned in the said rejection, while rejecting the representation, that the evaluation criteria was uniformly applied to all bidders, and there was neither relaxation of RFP nor unequal treatment. It was also mentioned that acceptance of a bid not demonstrating the mandatory eligibility requirements would have prejudiced other bidders and compromised the integrity of the procurement process. In the backdrop of the above, the question arises as to whether this court should entertain the instant writ petition, more particularly when the stand of the respondents is apparently clear from the communication dated 1/8/2026, as well as the rejection of the petitioner's representation dated 7/8/2026. First, in the foregoing paragraphs of the instant judgment, this court have duly quoted the requirements, and more particularly to clause 2.2.2.2 Roman 3 bracket C, which categorically of the RFP, which categorically mentioned as to what are the similar work experience required. The respondents have categorically mentioned in the communication dated 1/8/2026 that the petitioner did not submit the requisite similar experience in respect to 1 and 2 so and so and so and so. In this regard, this court finds it relevant to take note of the submission of Mr. R. Sinha, the learned counsel appearing on behalf of the petitioner, who submits that the major work is the case of slope protection, which the petitioner duly has. As regards the other two works for which similar work experience were required, pertains to procurement of materials from the vendors and thereupon fitting the same, installing the same. And therefore, the said requirement of those two clauses for the and under such circumstances, the rejection of the petitioner's bid on not having the similar experience certificates in respect to number 1 or number 2 editor cannot be a reasonable or a rational exercise of the power, as those certificates are only consequential to the main work of slope protection. This would have given an anxious consideration to the to the submission made on behalf of the petitioner, and have also taken note of the stand of the respondents as is discernible from the communication dated 1/8/2026 as well as 7/8/2026. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of AF Constu Bhoradibu. More particularly, paragraph number 16 or 15, paragraph 15, wherein the Supreme Court in clear and unambiguous terms have observed that the understanding of the terms of the tender should be best left to the tendering authority. The court, in exercise of the powers under judicial review, should not try to interpret contrary to the stand taken by the tendering authority unless a case of mala fide or perversity can be shown. The said proposition of law has been further followed in various judgments. Taking into paragraph 15 of the said judgment being relevant is reproduced hereunder. Taking into account the above proposition of law and the terms and conditions, as well as the conditions stipulated in clause 2.2.2.3 Roman C of the RFP, as well as the stand so taken by the respondents in the communication dated 1/8/2026 and 7/8/2026, to the effect that there is no certificates, that the requirement of the certificates were essential pertaining to the two works, namely so and so and so and so. 1 and 2 comma. And further, that the said aspect has been applied across all other bidders. This court is of the opinion that this is not a fit case for being entertained, for which this court is not inclined to issue notice in the present proceedings. Accordingly, the writ petition stands dismissed. However, in the facts of the case, this court is not inclined to impose any cost.
I'm deeply obliged, Your Lordship.
Lordship, on last occasion, my lord, the complete NIT I could, this is here, my lord, my market name is there, and I'm agree to violation of the clause 13, despite I'm with highest bidder, no reason assigned to me why my tender has not been considered, and settle the market with the aspirant number 5, second bidder.
Lordship, can it be on 21st? The alia matter, Lordship, please to fix,
Here is a different case.
my lord.
If you see the comparative statement,
Page 44, my lord.
page 40,
Page 4.
40.
Comparative, yes.
Yes, my lord.
Better please quote it. Yeah, okay. More
Private
like-
respondent,
more like-
no, just a minute,
Oh.
private respondent armed process.
Oh, wait.
Yes, your lordship. My lord.
That is why in the other case, I asked about that thing.
My lord,
Now here you cannot take that plea
my lord. Since
because
I-
his comparative
But-
statement shows that he is number one.
Yes,
It was shown as number, but what they have said, kindly see this particular document at page 44.
yes, my lord.
This has to be stated. And you run the market in the meantime? Till the next day. We can have it on the next day
Lordship,
and set aside if it is so.
lordship, we may be allowed to we'll run the market.
You run it without the private respondent. And on 21st, we fix it on that date. We have it on a later date this one.
Lordship,
We state this. Issue notice returnable on 28th of August 2026. Ms. N. Bora accepts notice on behalf of the respondent number one. Ms. So-and-so accepts notice on behalf of the respondent number 2, 3, and 4. Extra copies of the writ petitions be served upon the learned counsels during the course of the day.
My lord.
As regards the respondent number 5, the petitioner is directed to take steps by speed post during the course of the day. In addition to that, the petitioner is also directed to effect service upon the respondent number 5 by way of the stick, routed through the registry of this court and file an affidavit of service on or before the next date. A notice inviting tender dated 27/5/2026 was issued by the respondent number 4, 3, for settling of various markets, including the
Besimari,
Lalpul
Lalpul Open.
Open Weekly Market. The petitioner, along with 5 others, four others had participated in the said meeting. 5 others had participated in the said bid process for the Lalpul Open Weekly Market. It is the case of the petitioner that though the petitioner was the highest bidder and technically competent, the respondent number 3 had issued the communication on 27/7/2026 to the
Respondent 4, my lord. Video.
respondent number
4, my lord.
4
Video.
for settlement of the Lalpul Open Weekly Market in favor of the respondent number 5. It is the further case of the petitioner that in terms with clause 13 of the tender notice, it was the requirement that the highest bidder who is technically competent ought to be granted the contract, ought to be granted the settlement, unless for reasons to be recorded, the respondent, the concerned authority, the authority is concerned, the competent authority considers not to grant the contract tender, the award, the settlement in favor of the highest bidder. The learned counsel appearing on behalf of the petitioner submitted that the respondent number 3 in the impugned communication without any reasons, without assigning any reasons, have granted the approval for settlement of the Lalpul open weekly market in favor of the respondent number 5, though the respondent number 5's bid was much lower to that of the petitioner. This court have perused the materials on record, and it is the opinion of this court that the petitioner has been able to make out a strong case for grant of interim directions. Accordingly, this court directs the following interim directions. Number 1, till the next date. Number 1, the impugned communication dated 27th of July 2026 issued by the respondent number 3 to the respondent number 4 for settlement of the Lalpul open weekly market in favor of the respondent number 5 is stayed. Number 2, the respondent, in the meantime, this court observes and directs that the respondent authorities, that is the respondent numbers 2 to 4, shall be at liberty to run the Lalpul open weekly market without the involvement of the respondent number 5.
Much obliged.
My submission can be recorded.
What is there to submit?
Lordship, that they may be backed by some reason for not awarding contract to the private respondent.
Like Miss B. Bhuya, the learned senior counsel, assisted by so-and-so submits that there might have been some reasons which she will place on record by filing an affidavit. Next date of affidavit file equivalent did it.
Much obliged.
File affidavits on source. The affidavit be filed on or before, it was 28 take question by 26th. Yes.
Lordship's order is already there.
I made certain research in this. How is it possible? Yes. There is only one state which permits. You know why? If you see the targeted order, not the first one, not the second one, see the third amendment. There is a particular column. In that column, there is also mentioned as private players in the table. Then I searched, how is it possible? Then I could see the only one. MP has a targeted control order of 2015 by themselves, whereby they gave the power that the authorized agency can further subcontract. You need something to that. Without that, it is very difficult. With this, you cannot go ahead with the tender. So I think you should make a submission now that taking into account the judgment, you would recall and go ahead with a fresh tender. That's the only way.
Or with some corrigendum here also they can go ahead. But one thing Lordship may kindly see, the petitioner is a private firm.
He is not there, but can this court overlook it?
No.
Problem lies there. Petitioner has no business.
Lordship,
Petitioner has no locus also. But the fact remains that can this court not look into 2G? And more particularly when this court has already delivered a
Already,
judgment.
Lord-
Because otherwise what happens, you gave it, another person will come. And they will come up and say that, look here, they have given, again, the entire tender process will be
Mal-
put into AI and again searching for somebody.
to that extent, in view of Lordship's order, to that extent, they have to have a corrigendum and go ahead. Instead of cancelling the entire process, my lord, they can have a corrigendum and go ahead with that in team of the judge.
I think better.
Wanting my
Lordship.
permitting to mention. Not, I don't feel shy of telling your lordship that I was not aware of your lordship's order. And also, my lord, the order passed by Honorable Justice Nair till day before yesterday. This is my deficiency. I have gone through them. And also, I have gone through the judgment in detail passed by Justice Suman. Presently, a writ appeal against which is pending, with a status quo there, in respect of that particular factum and that particular operator, my lord. So I will just try to, lordship permitting, highlight, my lord, one or two paragraphs of your lordship judgment order. It was rather an order, my lord. This order, your lordship said, Asani copy did it?
In fact, my order does not say much.
That's right. Authorized
Justice
agency
Nayar's order says much on this aspect. and
directed
they
the,
carried out.
directed, my lord, 2 months, that within 2 months effective steps. And my lord, in that case, the allotment was given to some cooperative society which was not a GPS. So that paragraph 3, your lordship said. And paragraph 3 also, your lordship referred to Justice Nayar's order dated 7/8/25. I'm just bringing in 2-4 important things for the government, my lord. So this was your lordship's order, and my lord, which was subsequent to, then it said that nothing remains, which was subsequent to, my lord, Honorable Justice Nayar's order dated 7/8, which also, my lord, I will make a short reference to, lordship permitting. In here,
Yes.
yeah, Justice Nayar's order, my lord, in same case, my lord, it is in the IA liability. That the coordinate bench refers to, my lord, 6647, that was by, my lord, Justice Suman's order, paragraph 2. Then, my lord, I am skipping the, my lord, contentions raised by the counsel, Kamal Chaudhary. Then straightway, I take your lordship to, my lord, paragraph 20. Paragraph 20. Of, my lord, the order dated 7/8/25 by Justice Nayar, my lord.
Well, then,
Ase. What ase? Here, my lord, it says the term authority, authorized agency has been defined 2G to mean a concert department, and lifting can be only through authorized agency. And here, my lord, the order also, my lord, quoted paragraph 24 and 25 of, my lord, Honorable Justice Suman's judgment.
then
Here, 3-4 important things, my lord, emerge. It gave a leverage for 2 months. That all right, for 2 months you run it. But our mandate, the spirit of this courts as well as your lordship's order is that it must be confined to GPSs. And one thing is for sure, my lord, let me tell you, lordships, had it been, my lord, confined to the, my lord, GPSs only, instead of floating this tender, which was made open to the private parties, I would not have trouble by filing this petition. That's for sure, my lord. But to talk about whether by taking some leverage, now a status quo, writ appeal, here lies, my lord, 3 or 4 important aspects. Both your lordship's order and Justice Naya's order were 5-6 years after the division bench status quo order.
Huh?
Division bench status quo order was of 2018. 18.
My
Any.
orders are.
Or your lordship's order was of 2026. So even the paragraph, what Justice, my lord, Suman's judgment said that, yes, it is 2G. But in exigencies where it is not possible, then you can go to 711. Right. That can get, that is under, my lord, challenge. Then, my lord, question is, even there, my lord, it was indicated that the mechanism under 711 order can be adopted state when it is not possible to confine it to 2G as authorized agency. My lord, am I getting clear to you, lordship? The interim leverages, my lord, if any, granted by, my lord, the Justice Naya, which was 2 months leverage, all right, you are running it, run it for another 2 months. This leverage cannot be, my lord, used or rather misused by the state for all time to come. And what they have precisely done here. Lordship will definitely take the presumption that it is in the mind of the government that the spirit of your lordship's order, as well as the spirit of that order, irrespective of the status quo order, is become infractions. Main case is pending, my lord, 2028. Now, these are the laws. And the government, lordship will definitely take the plausible inference that it was very much within the knowledge of the government that they are to go by the GPSs. They are to go by the GPSs and not by any other authority.
No,
And
they can have their own company. Just for example, they can have their,
Yes.
if they have a own,
on.
if they have their own company,
Yes.
the company, and then that company may give it to anybody else, that is permissible. That I could see. I could find out that if you have a company, that company can subcontract is another thing, which is a different aspect of the matter.
My lord,
But this is otherwise is not permissible.
yes, yes. So, my lord, continuing, my lord. Then, my lord, definitely your lordships, the only plausible inference that it was very much within the knowledge of the government since 2018, and also the last year's orders, Justice Naya's order and the spirit of that order, my lord. And by every district of Assam with the same stipulation. They should have confined it to the, not like my case, my lord, where different districts also adopted different stipulations. Therefore, what I submit, had it allowed only to the GPSs, I would not have burdened your lordship by filing this petition as I have said. But since by the order I have impugned, they have made it open for the private participants, my lord, that's why I have filed. And more particularly, if by any leverage they wants to continue, that well, we are in a situation where GPS not possible, our own company or our own mechanism, then therefore we give as leverage to go for private partners, private participants. In that case, my lord, my arguments put forward that day, that you have put a very restrictive, my lord, clause in your tender that your lordship may record. Even otherwise, there is time, because as per the schedule, 18th is the last date. Well, if it is GPSs, my lord, I will not go anywhere. I will not go. Here ends my business. I will continue with my lord transportations, which I am doing under the FCA. But even in the corrigendum, my lord, it should be clear to all and sundry that this time it is only GPSs.
Now here you see, this amendment which was made to this order
Lordship.
On 15th of January 2024 to the targeted public distribution
2015.
order 2015.
Yes.
There was an amendment made by an order dated 15th of January 2024.
Yes.
To মই আপোনাৰ তাত পঠিয়াই দিছো যাব। What is your email to give her? Port 10. Port 10.
The judgment which is under writ appeal, my lord.
Mr. Barbara,
Your lordship.
while giving a judgment in the writ appeal, asking for a status quo, no sense, because still
No,
the
no.
judgment remains. It may not be effective for that party, but otherwise, the whatever may be. Now, here, if you see another an important aspect, I say.
I think I have the amended one. Right.
Ah.
Direct to come to. Lordship.
Down to election. তললে আহক, একদম তললে আহক, তললে তললে ওপৰলে যাব নালাগে, তললে আহক।
My lord,
তললে আহক।
which clause your lordship is
Yes,
suggesting me to read, my lord?
Just 1 minute, অকণ তললে আৰু অকণ তললে আহক, বা ওপৰলে যাওক, ওপৰলে যাওক, ওপৰ এই টেবুলখনলৈ আহক।
Yes.
Bas. Now, here if you see, have a look at it.
Lordship.
You see out here, serial number, name of the agency, type of the agency, number of districts, total, so and so. Then common asterisk to leho. Yes. As regards the type of agency, please indicate whether the state civil supplies corporation or other apex body cooperative society.
Wholesalers.
Private agency, example, wholesalers, large area multi-purpose cooperative societies, primary so-and-so, or any other agency. Now, upole koman ho, koman upole ho, bas ito. Now, here you see, what you see, therefore I'm saying subcontract is permissible. Serial number, name of the agency will be the authorized agency. Type of the agency will change.
Not.
Get the point?
Under the
It
authorized
has to
agency,
be
there will
in
be
that manner. If you do it, it is permissible. This is the amendment which was brought in 2024. So it has to be, you may have to have a state corporation. And that state corporation may then float a tender to give it.
Yes.
And thereby bring it. So it will be under the contract is given by to the authorized agency, but is being done, but it is done through private players. This is how it works. But you cannot directly, the state cannot give it.
Directly, not.
This is the only way out.
No.
Yes, my lord.
And if you see, they have a account structure. Madhya Pradesh, Madhya Pradesh account Marok, account no. On my internet at my internet at Marok. Madhya Pradesh targeted control order at Marok. The internet. There you find they have themselves made one for the purpose for the subcontract. So you need to have something to that effect which the state has to make.
In that way.
And thereby it is being done through. Now what happens? It is normally the authorized agency is the Madhya Pradesh, whatever that
Some
it is,
corporation.
transfer is the board.
You to put
And
us
that
not
board is putting it to that. Is the only way. Having all other terms is similar.
That's all.
But they mention there that they will do it to anybody. So now they get it. It is therefore, as per this, it is done by authorized. It's the only way.
Right.
No, that's all. That
Here
is
you see,
Lordship.
this is the year,
Lordship.
as I said. You see here, Whereas the state government is the opinion authorized, necessary and expedient so as to ensure availability of so and so ration to the airport. Now this is being done tolle how?
Yes.
Now they don't have the definition of authorized agency here. You see this?
Yes, I've seen.
They don't have. Now, how the distribution will be carried out? I think number 7 will be there. Huh? Number of paper allotment of
Definition-
your responsibility.
definition-
তলত হওক।
Definition 2D is there, my lord, authorized agency.
What does it say? 2G উপলে হকচোন।
Means Madhya Pradesh State Civil Service Supplies Corporation. which
তলত
includes its-
তলত 2G
2D. D, my lord.
I think
D.
Assam too.
means Madhya Pradesh State of Civil Supplies Corporation, which includes the officers so and so, so and so, so and so, along with authorized employees who are engaged in the transportation of so and so, so and so, from the stock of the corporation of area or decentralized to the centers of the area and then to the fair price shops. Now, in this manner, they are somewhere doing it. But this is the only state who is having a separate control order than the control order given by the state.
I think state has also
But
got.
one thing you have to understand, Madhya Pradesh is a pretty well-to-do state.
Mhm.
Whereas the state of Assam can take the risk.
That's
Because here is the
that
question
is-
of money being given by the center.
I think Assam has got a control order too, my lord. They can have a look at it in the line of
No,
Madhya
this
Pradesh.
This is in consonance with that.
If your lordship indicates that no private supplier, then my lord, lordship will, then I know, then I will not go into all this. If no private supplier is allowed, my lord, transporter, then lordship will make it clear. And they shouldn't enjoy leverage after leverage, my lord. No.
Because, Mr. Nath, the problem arises with what the judgment of Justice Shyam, more particularly at paragraph number
25,
27,
27.
is temporarily you may. Because otherwise this will go against 711 will go against 71.
we argue that on under 711 we have the power, we can have our own mechanism.
No,
That
that,
lordship has
that can be done temporarily.
Lordship-
For urgency, if it is required for that. Just for example, in COVID, times of those where COVID is there, so during that period of time, you may not find the cooperative society.
Lordship-
Then you may have to do it.
Yes,
The normal, because the main section, the 7.1 categorically mentions. So 7.1 cannot be mean that 7.11 overrides 7.1.
Yes,
lordship.
precisely, my lord. That's what, rightly.
In fact, Mr. Barbara, there is a very interesting judgment in the year 1955, which has been recently followed by Justice Amanullah in another judgment. While reading a contractual agreement, if your term, the terms which are there earlier, the subsequent terms cannot go against the earlier terms. The earlier terms, the subsequent terms has to be in consonance with the earlier. So therefore, if we take that judgment also, 711 cannot be said that it goes against 7.
It is a second alternative limb, 711. 2G is the basic requirement. And they got enough time, even after COVID, for last 4 years. Counted from 2022, now we are in August 2000.
You do one thing, you may issue a fresh tender or corrigendum, you do whatever you feel like, but it has to be limited to 7G.
My lord, the schedule is there. The 18th is the last date as per their tender.
Because they will extend it. Because in fact, in my opinion, what you have done is once you have issued the tender, you made a modification on 31/7.
Yes,
And thereby you have reduced the period, but thereby you have also enlarged the scope of participation.
that is what they.
Because if you see earlier, it was 2 years, you have to have two contracts experience, 2 years experience,
Gotcha.
and in the last 5 years. Now you say that 1 year experience for whatever years is immaterial. 1 year experience will do. It seems to be reasonable conditions out there. There's no problem. But whatever it is, but thereby when you have enlarged the scope, it was also the necessary at the time of corrigendum to enlarge the period also.
Period, they have kept only 26, 27 because they go financially.
No, not that. You see, the last date of submission has been put at 18/8.
18. That's true.
Then they say.
Now you change the very technical, one of the most important eligibility criteria, which means many other people will come in.
Mal-
But their period has been, for them to submit has been reduced, whereas those people who are having 2 years out of 5 years, they had the notice from that date. So
Ali.
therefore, it was required for extension of that. Anyway,
that's
you do it.
The Lordship will make it
they will
only
do.
clear
They will do.
that private contractors like FCI contractor like me, not eligible. My
Why
lord,
should I say
I will
like
not venture
FCI
out.
contractor?
I will not venture out.
As per
You follow 2G
yes, as per 2G
and 7.1.
7.1, Lordship has interpreted, will go by that.
The only and this is
Mr. A.C. Borbora, the Learned Senior Counsel, assisted by Mr. B.P. Bora, Learned Counsel for the petitioner. Mr. Dina, the Learned Senior Government Advocate, appears on behalf of
all the respondents. There are two major respondents, my lord, State of Assam by Commissioner Secretary, Food Civil Supplies. And here I made the District Commissioner Nagaudi party, my lord, because this tender was floated by Commissioner Nagaon.
appears on behalf of the respondents. The present writ petition is filed by the petitioner. Challenging the notice inviting tender
27/7.
dated 27/7/2026
Corrigendum
issued by the District Commissioner Nagaon,
and Corrigendum 31/7.
read with the corrigendum dated 31/7/2026, whereby the eligibility required for being qualified to submit the bid was fixed at, was mandated to be a bidder having 1 year experience of transportation of food grains under the NFSA 2013. The Learned Senior Counsel, appearing on behalf of the petitioner, submitted that the petitioner herein is carried on and has due experience of transportation of food grains with the Food Corporation of India,
and even for a state, my lord, I have stated.
as well as other state entities.
Civil works, including flood relief supply. Earlier years.
The restrictive clause of only permitting those persons, those bidders who have experience in of transportation of food grains under the NSFA 2013 is arbitrary and tailor-made and therefore requires to be interfered with.
And my lord, I refer
The
to
Learned Senior Counsel,
Bongaigaon tender. I have, sorry.
Mr. Borwai, take a seat. I know what to write. Take a seat. You need not. Mr. The Learned Senior Counsel further submitted that there is no rational nexus to the object sought to be achieved by creating a differential between bidders who have experience of transportation of food grains under the FCI with bidders who have experience of transportation of food grains under the NFSA 2013. The Learned Senior Counsel therefore submits that clause C1 of 2C1 of the impugned tender is required to be struck down. In addition to that, the Learned Senior Counsel also submitted that the state has the responsibility in terms with the targeted public distribution system bracket control order 2015 to distribute the food grains by transporting the food grains from the FCI Godown to GPSS oblique WCCS Godown and from GPSS oblique WCCS Godown to FPS dealer oblique agent. Under such circumstances, the delegate of the state, that is the district commissioner, has to follow a uniform guideline. In that regard, the Learned Counsel, Senior Counsel, referred to the impugned clause 2C1 of the impugned tender, and further referred to the tenders issued by the district commissioners in the district of Bongaigaon and Golaghat, wherein similar restrictive terms are not, wherein such restrictive conditions are not there. The Learned Counsel therefore submits, Senior Counsel therefore submits that the reason for which the instant impugned tender is required to be interfered with is on the ground the same is in violation of the mandate of Article 14 of the Constitution. When the writ petition was listed before this court on 12/8/2026, This court had posed the question upon Mr. Dina, the learned senior government advocate, as to whether the tender in the present, the impugned tender in the present form can at all be sustainable in terms with the order of 2015. Yeah, I got the order of 2000. In as much as in terms with clause 2G, the term authorized agency have been defined to mean the concerned department of the state government or a body corporate or a company owned by it or a cooperative. And further, at clause 7 bracket 1 of the order of 2015, it is only the state government who shall lift the food grains from the designated depots of the corporation through its authorized agency. Full stop. This court also drew the attention of Mr. D. Nath, the learned senior government advocate, of the order passed by this court in the case order passed by this court on 17/11/2025 in the case of Laipuli Gaon Panchayat Samabhai Samiti Limited and 15 others versus the Union of India and 3 others, rendered in WPC number 1924/2025. Today, Mr. Dina, the learned senior government advocate, submits that the ground on which the petitioner have approached this court cannot be said to be a ground submitted, that the petitioner have not been able to make out a case for violation of Article 14 of the Constitution, more particularly taking into account that the tendering authority, being the best judge of the requirement, can very well stipulate the experience clause, more particularly as in the instant case, the transportation is to be carried out under the NFSA 2013. 13, na? 13. In addition to that, the learned counsel, appearing on behalf of the petitioner, respondents, submitted that in terms of that those section 2G as well as clause 2G as well as clause 7.1 of the order of 2015 specifically stipulates that it is the state government who shall lift the food grains from the designated depots of the corporation through its authorized agency. But in terms with clause 7.11, the state governments can devise a suitable mechanism for transportation of the food grains from the corporation godown to the intermediate godown and the doorstep delivery of the food grains to their fair price shops. The learned counsel, senior government advocate, submits that this aspect may not have been looked into. In fact, Mr. Nath, I still remember in that case, not this order. Prior to that, I have categorically said 7.11 would not apply. There is a specific order in that case.
Not.
If you see that order, because here, because this I took it up for final disposal as to whether they had the locus.
They did not.
This finality was arrived at, but in between your submission, I have recorded and said that 7.11 not permissible.
Not permissible, because we argued in our affidavit. we argued
And I have passed an order in that regard.
Not.
That order is not here. submits that, so and so. This court have given an anxious consideration to the respective submissions.
Well, if Lordship kindly takes up the order of 711 in paragraph 6, well, that submission is recorded.
Of 1711.
17.
No, I have in detail dealt with in another order earlier. If you see that case,
Understood.
you will find out that in
Yes,
detail I have dealt with this
I'll check.
aspect. Because you made a submission to that effect. I remember that.
Well, to that effect, my submission, Lordship, in paragraph 7 has recorded.
Hmm.
I'll just check.
This court had given an anxious consideration to the respective submissions and have perused the materials on record. In addition to that, the learned senior government advocate further submits that even if applying clause 2G read with clause 7(1) of the order of 2015, the petitioner has no locus standi to approach this court. This court had given an anxious consideration to the respective submissions and have also perused the materials which have been placed on record. Let me take it at 2. Would not spoil your lunch. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the submissions made by the learned counsels, two points for determination arises for consideration. Number 1, whether the petitioner, being a private party, or for that, whether the petitioner, who is an independent contractor, would have the locus standi to participate in the tender process initiated by the impugned tender in view of clause 2G read with clause 7(1) of the order of 2015. Number 2, if yes, whether clause 2C, capital C, small 1, Roman 1, capital Roman 1, is in violation to Article 14 of the Constitution. NFSA condition. First point for determination. The NFSA, the National Food Security Act 2003 was enacted by the Parliament and enforced on 10/9/2013. Section 22 of the said Act of 2013. I say Act of 2013. Inter alia places the obligation on the central government to provide assistance to the state government in meeting the expenditure incurred by it towards the intrastate movement, handling of food grains and margins to be paid to the fair price shop dealers in accordance with the norms that may be prescribed by the central government. The said provision, that is section 22 of the Act of 2003, would therefore show that the Parliament was conscious of the aspect of the remuneration to be paid to the fair price shop dealers for the services rendered by them, namely of receiving, storing and distributing the food grains under the Act of 2003 to the beneficiaries from their shops. Pertinently, under the statutory scheme contained in the Act of 2003, the food grains are required to be offered by the fair price shops to the beneficiaries at fixed prices. In other words, it is not open to the fair price shop to sell the food grains at any other higher price. For the structure created under the Act of 2003, of which the fair price shops are an integral and essential part to stand and to function efficiently, it is essential that the financial viability of the fair price shop is maintained. This is also essential to discourage use of illegal and unfair means of fair price shop owners, such as adulteration or diversion of food grains from the real beneficiaries to the black market. It is in keeping with this objective that the central government issued the Order of 2015 under Section 3 of the Essential Commodities Act in supersession of the earlier PDS Order of 2001. Next. The Order of 2015 gives statutory recognition to the protection of financial viability of the fair price shop dealers / owners in terms with the provisions of the Order of 2015. The state government is therefore obliged to issue fair price shop license, keeping in view the viability of the fair price shops. The state government is also obliged to ensure that the number of ration card holders attached to the fair price shops are reasonable. The state government is also obliged to fix an amount as the fair price shop margin, which shall be periodically reviewed for ensuring sustained viability of the fair price shop operations. With a view to preserve the viability of the fair price shop operation, the state government is obliged to allow such fair price shop to sell commodities other than the food grains distributed under the Order of 2015. In this backdrop, if this court now takes note of the Order of 2015, It will show that clause 2G defines the term authorized agency. The said definition being relevant is reproduced hereunder. From a perusal of the above quoted definition, it would show that the said definition is an exhaustive definition, thereby confining the term authorized agency to the department of the state government or a body corporate or a company owned by it or a cooperative. In other words, a purely private party that is an independent contractor or a wholesaler with no state ownership do not fall within the close definition of the term authorized agency. Clause 7 is with the heading lifting of food grains by the state. Clause 7.1 being relevant, 7(1) being relevant is reproduced hereunder. From a perusal of the above quoted subclause 1 of clause 7 of the order of 2015 would show that the state government shall lift food grains from the designated depots of the corporation, that is the Food Corporation of India, to its authorized agency. In other words, the lifting of the food grains is expressly tied to the defined term authorized agency, and as such, a private party outside clause 2G categories cannot perform this specified function. This court also finds it relevant to take note of clause 7.11 of the order of 2015, the reference to which the learned senior government advocate for the government of Assam advocate have laid emphasis upon. The said clause is reproduced hereunder. From a perusal of the above quoted clause, it will show that the state government have been conferred with the power to devise suitable mechanism for transportation of food grains from the corporation godowns to the intermediate godown and the doorstep delivery of the food grains to the fair price shop, provided that the state government may also transport food grains directly to the fair price shop from the corporation godown and ensure its doorstep delivery to the fair price shop. It is relevant to take note of that in clause 711 of the order of 2015, there is no reference to the term authorized agency. Rather, it uses the broader, unrestricted phrase, inverted comma, suitable mechanism, leaving the choice of the transporter to the state government's discretion. In this context, this court now finds it relevant to take note of Annexure Roman 3, which is in connection with clause 712 of the order of 2015. The prescribed statement on doorstep delivery expressly contemplates reporting by the state civil supplies corporation or other apex body, cooperative societies, private agency. For example, wholesalers, lamps, PACs, etc., and other or any other agency confirming that the rule-making authority itself contemplated private agencies operating at the transportation/delivery stage distinct from lifting stage under clause 7.1. This court at this stage finds it relevant to take note of Section 32 of the Act of 2003-13, which empowers the state government to continue with or formulate food or nutrition-based plans or schemes providing for benefits higher than the benefits provided under the Act from its own resources. In other words, if the state of Assam wishes to provide additional benefits, the state of Assam can do so. But not in respect to the benefits which flows from the Act of 2003. For the purpose of providing benefits under the Act of 2003, it is the responsibility of the state to comply with the order of 2015. At this stage, this court finds it very relevant to take note of a judgment of the Delhi High Court. In the case of Delhi Sarkari's ration dealers Sangh versus the state (NCT) of Delhi, wherein a question arose as to whether the scheme which was formulated by the Delhi government for doorstep delivery was permissible in terms with the order of 2015. The division bench of the Delhi High Court categorically held that since the Act of 2003, which specifically requires that the scheme introduced by the central or the state government shall be in such area and manner as may be prescribed by the central government, the Delhi government was bound to implement the proposed doorstep delivery scheme only in the manner that the central government may prescribe and not otherwise. And accordingly, held that the scheme introduced by the Delhi government did not comply with the NF Act of 2003 and the order of 2015. It was further observed that the Delhi government was entitled to frame a scheme for doorstep delivery of the food grains, rations to the beneficiaries under the order of 2015 at the doorsteps of the targeted public distribution system beneficiaries. However, the same has to be done by the Delhi government from its own resources in compliance with the prevailing laws. In the backdrop of the above, let this court take note of the impugned tender notice. From a perusal of the impugned tender notice, it is seen that the tender notice is for handling and transport contractor and fixation of rate for transportation of the food grains under the Act of 2013 in a two-tier system, of which tier number 1 was from the FCI godown to the GPSS/WCCS godown, and tier number Roman 2 from GPSS/WCCS godown to FPS dealer/agent. In other words, what is being envisaged under the said tender is that the contractor who would be appointed shall lift the food grains from the FCI godown. In the backdrop of the above, if this court now takes note of clause 2C, Roman 2 and Roman 3, it will show that the said contract show that the bids were invited from not only from the GPSS/WCCS, but also from private player, independent contractors, such as a partnership firm, company, or even a proprietor. In the opinion of this court, taking into account the scheme of the Act of 2013, read with the order of 2015, initiation of the tender process, thereby allowing the contractor to lift food grains from the FCI godown would be contrary to
clause 7(1) of the Act of the Order of 2015, unless it is limited to the authorized agency as defined in 2G of the Order of 2015. Therefore, in the opinion of this court, clauses 2C Roman 2 and Roman 3 of the impugned tender dated 27/7/2026 runs counter to clause 7 Roman 1 of the Order of 2015, read with clause 2G of the said order. Let this court now take note of the question as to whether the petitioner has the locus standi. The petitioner herein admittedly is not and would not fall within the definition of clause 2G, inasmuch as the petitioner is an independent contractor having no relation with the state, government, or a cooperative society. Next, second point for determination. The second point for determination is as to whether the impugned notice inviting tender dated 27/7/2026 is in violation to Article 14 of the Constitution in view of clause 2C bracket Roman 1. Taking into account that the petitioner would not come within the ambit of an authorized agency in terms with clause 2G of the Act of the Order of 2015. It is the opinion of this court that the petitioner cannot be permitted to question the terms of the tender in the present proceedings. This opinion is based upon the fact that clause 2C1 Roman 2 and clause 2C Roman 3 runs contrary to the impugned tender, runs contrary to the Order of 2015. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. Clause 2C Roman 2 and 2C Roman 3 of the impugned tender dated 27/7/2026 runs contrary to clause 2G and clause 7(1) of the Order of 2015. And as such, the said two clauses stands interfered with
Number two, the District Commissioner Nagaon, who is the tendering authority, would either be at liberty to proceed with the present tender process, subject to issuance of a corrigendum that only a cooperative society would be entitled to participate in the said notice inviting tender. Number three, this court is not inclined to interfere with clause 2C1 of the impugned notice inviting tender dated 27/7/2026 for the reasons already recorded herein above.
But this one has been, a corrigendum has been issued. In respect of this 2C1, a corrigendum has been issued. So the one, originally it says 2 years experience. It was subsequently changed to 1 year.
It's okay. Therefore, I'm not interfering.
Okay.
What did I say? I did
And
not
the-
interfere with clause 2C1.
2C1 and the corrigendum, my lord, and the corrigendum.
I'm not interfered with clause 2C1.
Okay.
Once you issue a corrigendum, it is already there, na?
Okay.
We always go by the new one.
Okay.
I'm not interfering with that, whatever.
By the new corrigendum, the doors are closed for the private operators, that man lordship.
I made it very clear,
Yes, yes.
It's clear.
Okay.
distinctly clear.
All right.
In fact, if you read that judgment of that
Delhi.
greater, because Delhi Sarkar, even any scheme by the government without taking the concurrence of the central government is not permissible. This matter was there. It's a division bench judgment. So they formulated the scheme. If you remember, Delhi government wanted to do it directly. They did not want to involve anybody. So they made it there that this will save money, we'll get more money and all this thing. Then no, you cannot do that. If you are using the NFSA and the assistance so provided by the by the central government, then you cannot.
Approval of the
You want to do whatever you feel like, you do it. You purchase rice and want to give it easy, because here the rice is to be provided by the central government.
Under section 32, lordship has indicated.
Yeah.
Other welfare.
So otherwise you can do it, you feel like.
Lordship.
And therefore, because of 32, you have 711.
Not.
They are given the liberty to issue a corrigendum, which is minor optional for them or lordship's dictating.
I therefore shall proceed only by issuance of a corrigendum.
Clear, sir.
Either proceed with that or do whatever they feel like. That is their lookout. But I have set aside these two clauses.
May I please, your lordship. The petitioner is the highest valid bidder, your lordship, and market is settled with the private action number 7. Your lordship, it's a violation of clause 14, page 20, your lordship.
What has happened?
Page
You are the
20,
highest bidder.
lordship. My bid value is 78,999 and bid value of respondent 7 is 31,111, your lordship.
Where is the notice being sent that you are with reference to the money you have spent and directed to inform?
Page 18 is the NIT, yeah, page clause 14, page 20, 20 top.
The final order has been passed.
Lordship. Page 39 is the list of valid bidder, page 37, 38 is the vernacular, your lordship. 3 bidders is valid.
38 to the bid values of the month. This is given by the block development officer.
Lordship. And page 39 is the orders. The
Where is
council
the
had developed-
comparative statement anywhere?
No, I have not.
annexed, lordship.
But I have not found. We have asked him from the bidder, it is not provided, your lordship.
Schedule, my lord, schedule rate is 26,829. And bidders, bid value more than
Twice, Lordship,
Thrice.
twice, Lordship. More
So, do you have any clause by that? It can be reduced.
Maybe, Lordship,
No, no, no.
regarding clause 14,
Huh?
regarding clause violation, they stated clause 14, Lordship, NIT.
Shall
maybe
make settlement
taken
with
into
the highest
consideration,
bidder
Lordship.
if all the necessary so and so, yeah. Where is it says that the
Some
highest?
reason maybe,
Huh?
Lord. I will take instruction regarding clause 14, Lordship. Maybe results may be recorded by the competent authority. And because
It is not mentioned in the,
bid value is mass excessive, Lordship, highly excessive, maybe, Lordship. My
Yeah.
submission is.
in 2022-23, it was settled with 68,000.
Huh?
In earlier, Your Lordship, I am the previous lessee, Your Lordship. Last year I have settled with the petitioner, I have paid
No,
70.
they have not fixed the rate,
Rate not fixed, it should be settled with the highest
which
bidder.
is similar to the rate as per we have at clause 48 of the
40
Panchayat rules,
Lordship.
financial powers.
47.
এইটো item number এটা যে কৰিলো, এটাৰ লগত কৰি place stay কৰি দিব এইটো. You stayed and we are having it on 26th and order will be, I'm staying it. Hello, Lekho. Issue notice
No, no, actually.
returnable on
Item 49. Sim.
26th of August 2026.
28 fixed.
Eh?
Fixed on 28.
28. 28. Ms. Enbora accepts notice on behalf of the respondent number 1. Mr. So-and-so accepts notice on behalf of the respondent number 224. 224 and 6.
6, Lordship.
Mr. J. Hendick appears on, accepts notice on behalf of the respondent number 5. Extra copies of the writ petition be served during the course of the day. As regards the respondent number 7, steps be taken during the course of the day by way of speed post. In addition to that, steps also be affected and the service also be affected upon the respondent number 7 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner, in pursuance to a notice inviting tender dated 27/5/2026 in respect for issued for various markets, huts, parghats, etc. for the year 2026-27 participated in the tender process for Herberry Bill Daily Market, BHERBIL Daily Market. The petitioner was the highest bidder, having quoted 78,99,000.
1,000, Your Lordship. 78,999.
78,999. However, the respondent authorities have granted the contract settlement in favor of the respondent number 7, who had quoted 31,111.
Lordship.
The learned counsel appearing on behalf of the petitioner submits that the said act on the part of the respondents, more particularly the respondent number 3, by issuance of a communication dated 27/7/2026, thereby approving the settlement in favor of the respondent number 7, is contrary to clause 14 of the tender notice. This court, having perused the materials on record, is prima facie satisfied that the petitioner have been able, is satisfied that the petitioner has been able to make out a case for passing interim directions, inasmuch as it apparently appears there is a inasmuch as it prima facie appears that the tender, the settlement of the Bherabheri weekly market in favor of the respondent number 7 was contrary to clause 14 of the tender notice. Accordingly, this court passes the following interim directions till the next date. Number 1, the settlements were made in favor of the respondent number 7 of the Bherabheri weekly market for the year 2026-27 on the basis of the communication dated 5/8/2026 by the respondent number 6 is stayed. Number 2, the respondents authorities, more particularly the respondent numbers 2, 3, 4 and 6 shall be at liberty to run the said market with their own resources without involving the respondent number 7. Mr. Bottakur, yes, what happened?
And it is in process and certain documents were sought by secretary. It has been submitted in pursuance of the fresh financial sanction proposal. This
When?
is the latest communication of 13/8. Chief engineer has written to secretary that all documents have been freshly submitted in pursuance to a query.
Mr. So-and-so, the learned counsel appearing on behalf of the respondent have submitted that the chief engineer PHE Water have Government of Assam Public Health Engineering Department by the communication dated 13/8/2026 that all requisite documents details have been enclosed as sought for in the query made online against the FS proposal for making payment to the petitioner. The said document is kept on record and marked with the letter X. Taking into account the above, list this matter on 23rd of September 2026 for an update. In the meantime, the respondents shall take effective steps for dispersal of the amount to the petitioner. And provide an update.
Obliged.
What is this, Mr.
Malat,
Islam?
here in this case, the amount has already been paid.
Mr. R. Islam, the learned counsel appearing on behalf of the petitioner, submits that the amount for which that the judgment and order dated 23/7/2025 passed in WPC number 6859/2024 have already been complied with. Taking into account the above, the instant contempt proceeding stands dropped. Provide names.
Second also same.
Eh?
Second one also same. Item 10 also same.
Same date, different order.
Different order. That's date is
Order
23/7.
23/7. Macha.
May I please, my lord, petitioner took steps to serve notice upon the respondent, my lord.
And it was, as per office note, my lord, that the ID has not been returned, my lord, till date. And in the meantime, some part payment is made, my lord.
How much amount did you get?
My lord, it was two installment, 4,96,900.
Who is there for anybody? You are appearing?
On behalf of Dean at Lord.
Yes. Why haven't you made the payment?
Your Lordship, an amount of rupees 5,04,949 has been paid. Lordship, instructions are there.
What about the remaining?
So we have, Lordship, we have already submitted the bill amount. The amount has not been received due to paucity of the.
Okay. So we do one thing. How much amount you have paid?
5,04,949.
5 lakhs, 4,900.
949.
49
49.
have been paid out of 10 lakhs 87,398.
Yes, Lordship.
Remaining is in the process.
Yes.
Ms. So-and-so, the learned counsel appearing on behalf of the respondents
My lord,
submits.
as per instruction, my lord, 4,96,980 is paid, my lord.
There will be
I'm sorry.
deduction. Isn't it the contract? TDS is not there. There will be deduction. Submits that an amount of rupees 5 lakh 4,949 out of rupees 10 lakhs 87,398 have been paid to the petitioner after deducting the tax. So, the remaining, as regards the remaining amount, proposals have been submitted for payment. For proposals have been submitted so that the amount can be disbursed to the petitioner at an early date. List this matter on 5th of October 2026 for an update. The pendency of the contempt proceeding shall not bar the respondents to clear the remaining amount in the meantime.
May I please, Your Lordship? Lordship, as per the last order, we have issued notice to the respondent authorities. And Lordship, till today, we haven't got any payment yet. As per the last order, dated 31/10/2025, this honorable court was pleased to direct the respondent authorities to pay the amount after verifying the entitlements of the petitioner, an amount of 2,90,55,308 rupees, Lordship. Till today, the petitioner has tried in various way to connect to the respondent authorities, but there is no.
Who is to pay?
The PHE department.
I never said if it is my order. Why? This is not an
Lordship,
order.
Lordship, and
No,
page number 12.
No, madam, that is not the question. Here is a case where BTC has to pay.
Yes.
BTC?
No.
Yes.
The PHE department.
No. BTC.
Yes.
So
Lordship.
BTC, if it is payable, is 1 month verification, then pay as per Tamsir.
Yes.
Tamsir does not happen like that. Tamsir, whether your name is there.
Lordship, we have issued notice to the respondent authorities, but.
Anybody from BTC? Get hold of a BTC council. We'll have it wait. We'll ask them.
Lordship.
Service is not complete.
Lordship, we have issued notice and that has been received by the respondent authorities. The
How
notice.
do you know?
The notices are annexed here with along with the.
Yes, Mr. BTC. You have an extra copy of the petition?
I can share mine.
Please share it.
This is the last order.
Mr. Counsel,
Yes, Lordship.
You do one thing. This amount was to be paid by the BTC.
Yes.
Okay. I don't direct payment. The payment will be as per Tamsir Ali.
Yes, Lordship.
So therefore, what you need to find out on the next date, have you verified the entitlement? And if verified, what is the number of the petitioner in the chronological list maintained as per Tamsir Ali? Okay? Chalo. There is an application file alleging violation, willful and deliberate violation to the order passed by this court on 31/10/2025 in WPC number 14/11/2024, whereby this court had directed the respondent authorities, more particularly the respondent number 2, 4, 5, 6, and 7, in the said writ petition, to verify the entitlement of the petitioner on the basis of the work orders, and thereupon, if upon verification it is found that the petitioner is entitled to, then make payment in terms with the judgment of the full bench in the case of Tamsir Ali and others versus State of Assam and others reported in 2008 for GLT 1. This court have taken note of that the notice was issued by the coordinate bench of this court. However, none of the respondents have put in their appearance. This court therefore have named,
Musahari. BC Musahari, my lord. BC Musahari.
have requested so-and-so, the learned standing counsel of the BTC, to take instructions from the respondents in the instant proceedings as to whether the verification of the entitlement of the petitioner have been complied with, have been carried out. In terms with the order dated 31/10/2025 passed in WPC number 14/11/2024. And if so, whether the petitioner's name have been inserted in the chronological table, in the chronological list so prepared in terms with Tamsir Ali Supra. Footstep. A copy of the contempt petition be served upon him by the learned counsel for the petitioner by Monday. Footstep. The name of so-and-so will be shown in the cause list. List this matter again on 25th of September 2026 for an update.
Musahari.
In the meantime, if you have not done, do it.
Yes, Lordship.
That's the
Musahari.
why so many contempt? Yes, what is your contempt for?
Lordship, in the page number 9 is the operative part, the contextual amount, and notice was issued.
But therefore, irrigation, you follow Tamsir Ali.
Yes, Your Honor.
How can you pay this?
His name is listed serial number 74, my lord. His name is listed as
Serial number 72,
74, Your Honor.
74.
Yes.
You have a instruction? Hello, we close it. You can't get the money like this. This is an application filed alleging willful and deliberate violation to the order dated 23/4/2025 passed in WPC number 1876/2025, whereby there was a direction upon the respondent authorities, respondent number 2, that is the chief engineer, minor irrigation Assam, to verify the claim of the petitioner and thereupon to make payment within a period of 4 months. Full Miss
Yes, Your Honor.
D.S. Nave, the learned counsel who represents the respondent, have submitted that the irrigation department follows, well, the irrigation department, for the purpose of payment of the outstanding dues, follows the directions so passed in the case of Tamsir Ali versus State of Assam reported in so and so. And accordingly, upon verification being conducted, it was found that the petitioner is entitled to the amount of what?
As per 3,74,300.
Huh?
As per our petition.
No. What is your entitlement?
3 lakhs, Your Honor.
What?
What amount here? There's 3,670, 3,67,405.
Is found entitled to the amount so claimed.
Yes, Your Honor.
However, and accordingly, the petitioner's name have been put in the priority list for the financial year 2026-27 at serial number 75 for payment. Taking into account the above, so the said instructions were placed before this court. Is kept on record and marked with the letter X. Taking into account the above, this court does not find that the further continuation of the contempt proceedings are necessary. Accordingly, the contempt proceedings stands dropped. Public.
This case, I have filed affidavit and reply is also being filed, Lordship, but my record is not being tagged, Lordship.
Why?
Maybe I just know
Floods. Nowadays, lawyers always take the plea of floods. So I am asking you, floods
No,
at your
no,
home.
I'm never take, it's my responsibility always. If he does vicarious liability is with me, always myself, Lordship.
See? Vicarious liability.
Always myself, Lordship. All liability rests on me.
Liabilities on Mr. Sharma.
Lordship, can it be on Friday, Lordship?
No.
Actually,
We'll have it
government,
on some
Lord,
Tuesday
the
and
gov-
Thursday. This will require, it can't be disposed of
Actually,
on
government-
Friday.
government has to take a call because the settlement order, which was passed, it was passed in favor of the first highest bidder. But he chose that he will not accept, withdraw. Then now the question comes, my client, Mr. Kotoki's client and Mr. Count's client. There are 3 clients. So I am the second highest, Count is third and Kotoki is fourth. All 3 read petition has been filed before this court, alleging allegation against all of us.
Who is running?
So nobody is running. That's the no, it's a lying cast. That's why. A lying cast. Actually, government has to take a call, my lord.
Anyways, the fish is not good now. What do you say?
No, Lordship, our fish is good.
Oh, your fish is good.
The fish which Lordship used to get, it is not ours. It is
The
from
lordship will
outside.
fix a date, my lord.
Outside. What?
No, your
Outside
lord.
Assam, Lordship. They are all.
We don't get an opportunity to get the fish from Mr. Sharma's fisheries. And Mr. Sharma knows that also. Therefore says that I don't get
No,
the fish from
I
anywhere.
stopped taking fish, Lord.
Huh?
I become vegetarian. Since
Your
last-
fish.
Since 2 years. One is thinking about fish. Lord.
Hello, I think we need to finish up the matter early.
Yes.
Lordship, actually, I have some armed force terminals on Friday, Lordship.
What you have?
Some matter in armed force, Lordship.
You're from fish to now you have gone to army.
Yes.
What?
I'm always.
It's busy everywhere. Hello. Like you're gonna. কেনেকুৱা অৱস্থা কেতিয়া দিব পাৰিম আগষ্ট না আগষ্ট impossible September anyways now the fish you can't have it September na huh when
They are saying 10 September.
taking into account that the pleadings are complete is the matter for final disposal on 10th of September 2026. On the next date, Mr. P. Sharma, the learned standing counsel of the
No, Fishery Department.
Fishery Department shall also produce the records.
File of
Oh, this one.
No.
What do you want?
I may be allowed 2 weeks time to file affidavit in reply. They file affidavit in opposition.
What is there? To file reply.
Lordship, I am appearing for.
We do one thing, we admit this petition,
Yes.
fix it for hearing. In the meantime, if you want to file a
Madam-
reply.
Madam.
This is the present petition has been filed challenging the award dated 5/7/2023 passed by the learned presiding officer Labor Court in reference case number 5/2022, whereby the dismissal of the petitioner from service have been upheld. So, taking into account that the records are available, this court fixes the writ petition, this court issues rule. It issues rule, thereby admitting the writ petition. There would be no necessity of issuance of any fresh notice, taking into account that the respondents are duly served with copies of the writ petition. List this matter for hearing on 2nd of December 2026. In the meantime, the petitioner is granted the liberty to bring on record its reply to the affidavit in opposition filed by the respondent number 1. The said affidavit in reply be filed on or before 23rd of November 2026. Yes, non-payment.
Yes, your lordship.
What happened?
Your lordship, the respondent.
Health. Where is health? What do they say?
Your lordship, the respondents have filed an additional affidavit in which they have produced a forged document that.
Have the respondents filed their affidavit?
Yes, your lordship.
What do they say?
They have filed a letter stating that the petitioners, some of the petitioners' employee have sent a letter to the respondents stating that the load.
Upon discussion with APDCL authority, they have ensured that the contractors had only deposited the supervision charge to the event amounting to rupees 1 lakh so and so. But the petitioner did not make any load security payment to the APDCL, that is rupees so and so. In this connection, the joint director of Iman is so and so. What are you asking for, madam?
Your lordship, we will file a reply to the additional affidavit in opposition.
Understood. What you are asking?
Your lordship, 1 week time may be granted.
To release and pay the security deposit and performance security which was deposited by the petitioner in terms of so and so. So
We have already
they
filed.
say that you have not deposited
We have already deposited the amount, your lordship.
243. 2,43,000 you have deposited.
Yes, your lordship.
Then what do you file? You file a reply also.
Yes, your lordship.
What do you say in the reply?
Your lordship, they have produced a forged document as annexure to page number 67. It is a letter, your lordship, stating that
Page
67, your lordship.
67. With reference to this here, I would like to inform you that 100 care will be charged within so and so. All papers and charging approval is already submitted in APDCL authority. And they ensure that the transformer will charge it within so and so. After receiving the official copy for deposited the load security amount, we will immediately deposit the same amount to the APDCL.
Your lordship, there is no such person in the petitioner's firm named as C. Bhattacharya, your lordship.
We want to file a reply petition with this regard, Your Lordship.
You want to file a sir rejoinder,
Your Lordship, reply to this.
reply to reply.
Your Lordship, they have filed.
Isn't it an affidavit in reply to your additional affidavit in reply? So, the question as to whether you have deposited or not,
Yes,
they
Your
have
Lordship.
denied, you have said that it is not so. Isn't it a question of fact to be decided by a civil court? What is your name?
Tina Buragoha, Your Lordship.
Where is your senior, Mr. B. Paul?
He's in some another court, Your Lordship.
Yes.
Your Lordship, 1 week time may be granted. We'll file a reply to their
I
affidavit.
can't
of
allow you
petition.
so much of replies. But anyway,
Your
I won't dismiss it in your hands. We will dismiss in the hands of your senior. Okay? Tell your senior.
much, sir.
The counsel for the health department being not present, the court could not, this instant writ petition could not be taken up for final disposal. Accordingly, list this matter on 7th of September.
Much obliged, Your Lordship.
Wait, please, my lord. My lord, this is regarding the refunding amount of.
You have not got the money?
No, my lord.
Instruction I already been placed in last date, Lordship. Lordship was directed to my lord file an affidavit on the basis of that instruction. I could not be filed, my lord. It was my lord, that instruction dated 25/2026.
Who is the person responsible?
My lord, for the.
Non-release of the funds? Who is not releasing you money?
My lord, the sub-registrar, my lord.
Chalo, let's see the face of him.
It was sent to the my lord, treasury. Treasury my lord said that
The Stock Holding Corporation of India, who is to respond primarily? Because the stamps are purchased electronically, nowadays purchased electronically. And the seller is Stock Holding Corporation, they have their own electronic system in place. Now, after having purchased the stamp for a deed of conveyance, that was rejected, that it is some difficulty. For some reason, it was rejected. That is not acceptable. Now, so far the refund part is concerned, because the money has flown to Stock Holding Corporation of India. So it is they who will have to put that system in place. Now, this instruction says, my lord, that it is linked with, my lord, the Field Assam portal. The Field Assam portal, at second paragraph, lordship will find in that instruction, my lord. It is 25/26. The Field Assam portal is a portal, my lord, at which is in use, my lord, for carrying out all the monetary transactions electronically. So far as, my lord, the affairs of the state of Assam are concerned, my lord. Here it is a particular peculiar case, my lord, and we have taken, my lord, a verbal instruction today morning, my lord, from the office of the Directorate of Land Records, my lord, as also from the department,
they say, my lord, it is not only the solitary two petitioners. Similar, almost, my lord, 300 my lord, matters are now pending. My lord, almost 300 persons, my lord. They have also purchased those electronic, my lord, e-stamps, my lord, for electronic vote. And those were, my lord, found not acceptable, and then they are seeking refund of the money, which is not, my lord, being provided to them in those.
Why?
Because now that system is not in place, my lord. So therefore, my lord.
Who is not providing? The stock holding company.
Stockholding corporation, and they now say, my lord, that they are taking up the matter.
What about the service upon the respond number
My
3 and 4?
service has been deemed complete, my lord.
Because money has flown to stockholding corporation. They are the custodian of money, and they are the custodian of, my lord, electronically issuing, my lord, these e-stamps.
So your stand therefore is that unless the amount is not provided by the stock company,
For a designated, my lord.
I'm not, Mr. Borpujari, make it simple. Your stand is that unless the stock holding company is not providing the fund, the refund of the amount, you are not in a position to provide to the petition.
The petitioner, number one, and number two, nonetheless, that being the situation, precarious situation, the department is taking up the matter, my lord, to find out a possible, my lord, solution, to find out a system in the, my lord, portal, whether that can be routed through FinAssam portal. Because FinAssam portal, that doesn't recognize this kind of transaction. That is the difficulty, man. That is the difficulty.
So you mean to say today, if any citizen purchases any stumps and some transaction does not happen, the stamps becomes non-negotiable.
So,
Means you can return it back.
because so far as refunding back the money, that, my lord, that option is not available in the portal.
I'm not on the portal business.
So this is because of the portal.
The portal is managed by the finance department.
No, therefore,
You have made the portal, or NIC has made the portal.
this is NIC.
NIC has made the portal.
Yes.
If you are not in a position to do so, but how do you take care of the loss which is being suffered by the petitioner on account of not refunding? How much is the amount?
My lord, there are two writ petitions. The first one is, my lord, 1,12,840. And the second one is 67,620.
Now the authorities are taking up the matter with NIC, because ultimately it will be NIC, my lord. We have to, my lord, design a system, my lord, which will, my lord, facilitate refund of money. And
No, so therefore, without the NIC making it in the portal, or in other words, the inefficiency of the finance department read with the NIC, a citizen can be deprived of his dues for a long time.
So finance has no role as such in this matter.
No, you say that because of it is not there in FinAssam portal.
FinAssam portal, my lord, because for FinAssam portal, we are not supposed to refund the fund. Nonetheless, an attempt was made. Because this instruction says so. An attempt was made.
Now, my question is very simple. A person purchases the stamp. The cancellation, the stamp is cancelled in terms with the Indian Stamp Act.
Yes.
The stamp has been cancelled. So once it is being cancelled, isn't it the duty of the register will be the deputy commissioner to return it?
Therefore,
That's the law.
that's the law, yes.
Now you bring in the FinAssam portal, whatever portal, I'm not concerned, but that is the law.
That is the law.
So if that is the law, why I'm not concerned how finance department has money or not, and that is their lookout. But this amount has to be paid. This cannot go on like this. Let's see the Indian Stamp Act. Can we impose interest upon the notice?
Now they say, my lord, that it will take another almost 2 months, my lord, to get the system on place, my lord. They are trying it, my lord, with NIC.
No, we are not concerned with the finance department. We are concerned with the register or the deputy register, sub-register. The register have cancelled it.
Register have not cancelled it, my lord.
Yes, they have cancelled it.
Yes.
You see the instruction of him.
It is stated, my lord, that
How the stamp is done? Time of stamping. Only one instrument.
paragraph number 5 of the writ petition, my lord. The first writ petition, 3037. The sub-register has refused, my lord. He said, my lord, that it was not accepted by the sub-register. Then a request was made, my lord, to the stockholding corporation. They have made a representation to the stockholding corporation.
Page 15.
Case 15, my lord, for refund of the money. Because payment was made for the portal of stockholding corporation. So we are only the executing authorities, my lord, registering authority. We are not the stamp issuing authority, my lord.
No, where is the provision for refund? Madam, where is the provision for refund? As per the Indian Stamp Act, where is the provision for refund?
Section 30.
Yeah, 49, yeah, allowance for stamps in here. Subject to such rules as may be made by the state government as to the evidence to be required or inquired to be made, the collector on application made within the period prescribed in section 50. And if he is satisfied as to the fact made, allowance for impressed amounts spoiled in the cases herein after mentioned. The stamp on any paper inadvertently unindulgently spoiled, obliterated, or by error in writing or any other means rendered unfit for the purpose intended before an instrument written thereon is executed. The stamp or any other amount which is written out wholly or in part but which is not signed or executed by any party. In the bills of exchange, the stamp used for instrument executed by so and so he is afterwards found to be absolutely void for law for the time being. So and so, so and so. Provided that in the case of executed instrument, no legal proceedings here. Application.
Section 39, my lord, speaks about, my lord, collector's power to refund penalty, my lord, only.
No, penalty is not there. Where any person has inadvertently used any instrument. Did you use the instrument?
No, my lord.
Why did you purchase?
My lord, for registration of a property in Tinsukia, my lord.
Then what happened?
My lord, when it was presented, my lord, we were told that it is unacceptable.
Why?
My lord, that I'll have to take instructions, my lord, but that is
Cannot
what.
be said like that. Because is there any communication by them?
No, my lord, it was all verbal. After
No,
that, we.
verbal things cannot work, na? How can we issue a writ unless it is verbal?
My lord, that fact is.
Have you mentioned it in your statement, statement categorical,
My lord,
in your affidavit, in your petition?
Paragraph 5, my lord.
What
page
do you
5,
say?
That pursuant to the purchase of the e-stamp, the petitioner submitted the e-stamp before the office of the sub-registrar Tinsukia for the purpose of registration. However, to his shock and surprise, he was informed that the e-stamp as submitted by the petitioner was unacceptable.
File your reply. Did you, what is your step? Understand has been sent a communication to the stockholding to ascertain the genuineness of the stamp amounting to rupees so and so only. According to submitted a report regarding the same. Where is the enclosed report? Where is stockholding company?
My lord,
You are providing me an instruction. Have a look at it. You have a copy?
I don't have that, only one copy.
See? Read the first paragraph. Stock angle पढ़ा है।
Lord, because there was some sort of a communication between the stockholding and the sub-registry, my lord. The previous council appearing had supplied some sort of an instruction, my lord.
Now, where's the report of the stock holding company? Let's see.
Oh. Treasury deposit
Therefore, in view of this report, it appears to be genuine. If it is genuine, then how do you refund it? If it is spoiled also, you refund it.
In the last page, Lordship will find, my lord, they have, my lord, deposited almost 16 lakhs rupees, my lord. Yes, with regard to other transactions also. There is a treasury salam.
15 lakhs.
98,840.
One, two, three, eight. 1, 2, 3, 8. 1. Mr. Borpuzari, look into the section 49. Subject to such rules as may be made by the state government as to the evidence to be required or the inquiry to be made, the collector may, on an application made within the period specified in section 50, and if he is satisfied as to the facts, make allowance for impressed sums spoiled in the case of hereinafter. So this is the stamp used for executed by any party thereto. He has afterwards found to be absolutely void becomes unless in consequence to alia, then the application in case of a stamp paper in which an instrument has been executed by any of the party within 6 months after the instrument or if it's so and so. The spoiled iman
We have received the instruction from the sub-register that I have found. They say, my lord, that there is no official record of such refusal.
now from this report, there is a report. The e-stamp is genuine.
Please send the genuine, and my lord, lordship will kindly see, when I have just found in my file, my lord. I apologize, my lord, I want to have given the instruction. This is from the sub-register Tinchukia, my lord, where the petitioner had, my lord, sought to register that. My lord, in reply to paragraph number 3 of the writ petition.
But anyway,
They say, my lord, that
so therefore if there is no refusal, there's a requirement of filing an application. Have you filed an application I think the application has to be filed for allowance for stamps in so and so. This will come under chapter 5.
yes.
There has to be a proceedings and have the Assam government made rules in that regard?
There, my lord.
Huh?
Rules has to be there. One fact that is, my lord, emerging from the instruction is that, my lord, contrary to what is spelled out by the writ petitioner in the writ petition, there is no refusal. I feel quite so, my lord, that I may not submit in that way, my lord, that petitioner has abandoned in his interest, my lord, to go for a conveyance deed, my lord. Maybe, I do not know.
No, for example, if you see chapter 5, even unused stamps or even used but not effectively put into use or spoiled stamp, allowance is being given. Allowance means I think the amount is to return. But this is subject to rules being framed by the state.
Yes.
Now, has the state framed any rules?
I will have to, my lord, thank you. Lordship, give me some time.
And in the meantime, you file your affidavit.
Lordship.
Because this aspect, what you are saying is that no official record of such refusal is available by the then sub-register Tinsuki of the e-stamp produced by the petitioner. Your affidavit.
Lordship.
And you need to, how do you apply? There are certain limitations provided there. When did you apply? Application has to be made in terms with that act.
My lord, post the,
Proceedings is not the resort. Everywhere nowadays we see everybody just has nothing. The writ petition is the only way.
Lordship, the what order, my lord, one letter, my lord, that was issued by that classic to the, my lord, that sub-register, lordship. This is order, my lord, the letter dated 26/8, lordship. It is I already been submitted.
You do one thing, you file your affidavit, lordship. On behalf of the sub-register, bring the stock holding document on record. Okay? And whatever your stand is, Lordship. And you file an affidavit that what is the course of action required to be taken. Okay. Heard Mr. N. Upadhyay, Learned Counsel, appearing on behalf of the petitioner. Mr. R. Bopujari appears on behalf of the finance or revenue?
Finance is not a party in both the.
On behalf of the Revenue and Disaster Management Department. The J. Hendrick, the Learned Counsel, who appears on behalf of the District Commissioner. Okay,
Lordship,
as, who is the collector. And as well as the sub-register. Insukia.
Collector is not a met party, Lordship. Only the sub-register is met party. They respond about 2 Lordship.
Benefit by the sub-register.
Who is going to refund
They
you?
have to implement the register as a party.
Who is going to refund you?
My lord, I have made the sub-registrar Tinsukia party, but later on, as per the instructions, we came to know that the money has been deposited. The communication was made by the stockholding to the sub-registry Kamruk, my lord.
Not on that, madam. My question is, who is going to refund it to you? The refund has to be made by the collector.
Yes, my lord.
The name collector is because of that. He collects and then pays. Proceedings are before the collector.
My lord.
Even then, Lordship, my lord,
Appears on behalf of the respondent number 2.
Lordship, may kindly see the
Various documents have been placed by both the finance department, both the council appearing on behalf of the sub-register, on behalf of the respondent number 1 and the respondent number 2, as well as certain report of the respondent number 3. It is the opinion of this court that these documents be brought on record by filing an affidavit by the respondent number 2. Including the report so submitted by the respondent number 3. This court also inquired with Mr. Arbopujay, the respondent number 1, as to whether any rules have been framed by the state of Assam in connection with Chapter 5 of the Indian Stamp Act. And what is the procedure when there is a requirement of refund? Mr. Arbopujay submits that he would file an affidavit in that regard. Taking into account that the issue is of greater importance, taking into account is of greater importance in as much as it is the very submission of the respondents that on account of proper facilities not being provided as regards the refund of the e-stamp available in the FIN portal, FIN Assam portal. The Mr. Arbopujari, the learned counsel, who is also the standing counsel of the finance department, shall also obtain the instructions from the finance department. The affidavits as directed here above be filed on or before 16th of September 2026. This matter on 18th of September 2026.
Grateful.
Please, your lordship.
What is this?
Non-payment of contractual dues, your lordship.
Which department?
Police
Ah.
and home department. As per the last order, your lordship, we have.
We have received instruction, my lord. Petitioner is supposed to
submit GST bill and others, my lord, document. Provided? Not yet, my lord.
Lordship, my vehicle was taken on hire charge basis with effect from 1/4/2023, Your Lordship. It is a private vehicle that was being taken, Your Lordship. Now they are asking that I should file GST. My vehicle was a private vehicle, Your Lordship,
They have requisitioned it
acquisition,
or taken on hire.
hire charge basis.
Hire cannot be, hire will obviously, there will be a question of payment of here, GST.
But the petitioner does not have any GST or this thing, Your Lordship.
How did you give it on hire?
No, they have taken, Your Lordship. They have utilized it, taken it, utilized it, and they have admitted
But
that
on the first hand, how did you give it?
there was a request, Your Lordship, at that time.
There cannot be a request. Tomorrow your car, we request you, we will give it.
The authority has taken it legally, Your Lordship.
How?
Initially,
Forcefully.
for 4 months, they have paid also. Initial 4 months they paid, subsequent payments were not made. And the vehicle was released, Your Lordship.
When was it released?
It was released on 21/5/2025. Lordship
So
will
then-
kindly see their affidavit in opposition. Paragraph number 4 of the affidavit, page 15, Your Lordship. That with regard to the statements so and so, the deponent respectfully states that the petitioner's vehicle bearing registration number so and so was hired for the purpose of maintenance of law and order duty as per the provisions of so and so, following the per diem rate fixed by the Transport Department, Government of Assam, in their notification dated so and so in various dates from 1/4/2023, and released the vehicle on 21/5/2025. The deponent further states that the petitioner has already admitted in the petition that he has received an amount of rupees so and so for the period from so and so, and amount of so and so for the period so and so. Paragraph 5, Your Lordship.
Let's see your bill. There is a bill.
The amount.
Get yourself registered.
Lordship.
Get yourself registered. GST.
But private.
Goods
a
and
private-
service tax. This is service.
Private individual cannot get registered here.
What?
Private individual.
Then why are you putting the bill?
No, I have.
You can't put in the bill. Are these people not private individuals who are selling out there in the shops?
No, but he's not private. He does not.
What? You are not entitled to. I think you should not pay. You guys don't know. We reject your payment. Yeah, you put it also GST. Kindly see your bill, page 9. See that? GST 5%. See?
It is there.
CGST 2% and how are you going to claim? Why are you charging GST without being registered? This is a serious case of fraud. I think the GST department should immediately seize the vehicle and take all the money.
This is their format,
Penalty
Your Lordship.
under so
This
and
is
so.
their format only, Your Lordship. We have.
Huh?
This is the format provided by them. We have.
Why did you put the GST amount? My question is.
8,200.
Why did you put the GST amount? Yes, Mr. K. Gogoi. You are for the central government also. He is charging GST, but he doesn't have a GST registration. Is it possible? Cannot. Isn't it a case of 74 not paid with an intention to willfully evade payment of tax? How can you charge GST?
That cannot be lost.
And he says down below, see, GST number nil. And the counsel who is going to and the judge Kindly see page 10, Mr. Counsel. This is a very serious thing which you have done, whoever has certified it. Down below, there is no mention that the GST is nil in the typed copy. Why? Isn't it a case of suppression? Because this document is otherwise not legible. I'm a young judge, so I'm able to read it, but not you. What will happen? Isn't it, Mr. Gogoi? Very serious. You dismiss with a cost of 2 lakhs.
They have admitted the liability, your lordship.
So what?
And
You know what is to be done. GST, you have to register yourself. You register and submit it, they will pay. এখন affidavit খনৰ মতে dispose of কৰি দিব হা paragraph
Lordship, let me take a instruction. Let it come day after tomorrow, your lordship.
not necessary 10,03,396 পাব বুলি লেখা আছে paragraph 5 ত কৰি দি পুলিচৰ কেছ খালি এটা লিখিব লাগিব তলত লিখিব দিয়া the payment shall only be made pursuant to the petitioner getting itself registered under the provisions of the Central Goods and Service Tax Act 2017 and producing the registration certificate, producing the GSTN number, GSTN, to the respondent authorities.
One date, lordship, I met.
Period of 6 months shall be counted only from the date of submission of the certified copy of this order to the Director General of Police, along with the copy of the registration certificate of the petitioner under the CGST Act 2017.
Oblige, lordship.
Being a Friday, I did not dismiss with cost.
Oblige, lordship.
What is this? Oh, yes, madam. You filed your affidavits.
Executive officer was, post of executive officer lying, recently he had joined new incumbent on 6th of August. He had joined the office. But could not take any.
Appearing for Dhubri Municipal Corporation.
8 and 9.
You are appearing. You file your affidavit.
Sometime in
Respondent number
8 and 9.
8 and 9. You have appeared on the last occasion on 15/7 also.
The executive officer.
And
I could not file the Okalatnama of executive officer. After lying second on 6th.
okay, a final opportunity is granted to both the Panchayat. Panchayat Rural has filed affidavit to the Panchayat and Rural Development Department as well as the Dhubri Municipal Board Corporation, Municipal Corporation Board to file their response to the instant proceedings as well as provide instructions in terms with the order passed by this court on 10/11/2025. First up, list this matter on 23rd of September 2026. In the meantime, the affidavits be filed. Madam, you are squarely responsible. No, demarcate is okay. I'm asking you to file the affidavit because both of you need to take it up because he says that it is, she says that it is in some village area. You say it is not village. They say it to be municipality. So therefore it needs to be done. Anyways, Raju Cloth House comes next. Yes, Mr. Nayak, what is this
In
case?
this matter, let my affidavit be filed, Lordship. It has already been forwarded to the authority for filing.
Supply of school uniforms. What has happened to the school uniforms?
Yes, Lordship, that in this case, Lordship, they have been barred, Lordship. This is item 25. Another item is 33, Lordship. Different entities, but they are using the same GST number.
Item number?
33.
33 to this.
Lordship, in this case, my senior Purukayasa sir is suffering from eye infection, severe eye infection, so he could not able to address this code. Lordship. Some short accommodation.
Let my affidavit.
You are saying that both are same entity? 25 and
Different entity.
33.
One is Raju Clothes Store, another is Raju Enterprise. But
They are one entity. So we take both.
yes, Lordship. In fact, that is why Lordship both the matters listed today. Lord.
It has been submitted by Mr. P. Nayak, the learned additional advocate general, that the present writ petition being WPC number 51 oblique 2026 is connected with WPC number 1305 oblique 2026. Inasmuch as both the entities which are proprietorship firms, these are proprietorship,
Proprietorship
firms,
form.
are being run by the single proprietor,
Yes, Lordship.
isn't it?
Yes.
Accordingly, WPC
And then
number the present writ petition be tagged along with WPC number 1305 oblique 2026. The Mr. P. Nayak, the learned additional advocate general, submits that 4 weeks time may be granted for filing the affidavit. To list this matter again on 28th of September 2026. In the meantime, the affidavit be filed on or before 22nd of September 2026 in both the repetitions. One affidavit will do, or both. There are two orders, na?
Two affidavit will file. Lordship.
Affidavit be filed in both the repetitions. Huh? One.
26 and 27 Lordship, exactly similar GST part, right?
Non-payment,
Lordship.
police,
Police Lordship. GST column maybe.
same,
Same
GST problem.
GST. Problem.
Okay, get yourself registered and then you'll get the.
Lordship, we have supplied the
You will first register yourself,
Lordship.
submit your registration certificate, then because what happens, you see, the GST is one needs to understand, it is both are connected. The moment if they don't pay the GST, they are in trouble. And you cannot also make a bill without a GST because this is a service. X কৰি দিছো, amount is how much payable. You admit the amount.
Lordship, the immediate portion is not there, otherwise GST and other things is there. So Lordship may verify and
No, it will be verified.
Verify. Lordship.
So he will submit the certified copy of this order.
Along with the GST registration number and so it will verify.
Along with the GST registration number, then they will verify
Lordship.
and pay within 6 months.
And you don't have Lordship.
ঠিক আছে? এটা X করে দিব। Submits the Mr. So-and-so has submitted that though the vehicles mentioned in the writ petition were hired by the police of commissionerate for maintenance of law and order, but while verifying the bills claimed by the petitioner, it came to light that the petitioner did not submit up-to-date RC and insurance along with GST bracket 3B form, driving license, declaration certificate. The petitioner, it was also mentioned that the petitioner was also informed to submit the correct documents to the office for further verification. Taking into account the above, the said the instruction is kept on record and marked with the letter X. Taking into account the above, it is the opinion of this court that as it is an admitted fact that the petitioner's vehicles were taken on hire, the petitioner would be entitled to certain amounts as per the would be entitled to the amounts, proper verification. The verification has to be carried out upon submission of the registration certificate, insurance, along with the GST 3B form, comma, driving license, declaration certificate. The counsel appearing on behalf of the petitioner submits that the necessary documents would be submitted. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The petitioner is that shall submit a certified copy. The petitioner the petitioner is granted the liberty to submit. Now, the petitioner shall submit the RC and insurance along with the GST 3B form, comma, driving license, declaration certificate, with the certified copy of this order. Number one. Number two, upon receipt of the said to whom? To the Office of the Director General of Police. So upon receipt of the said documents along with the certified copy of this order, the respondent shall verify the entitlement of the petitioner. And upon verification, if it is found that the petitioner is entitled to the amount so claimed or any other amount, the said amount be paid to the petitioner. The said exercise be completed within a period of 6 months from the submission of the documents as aforesaid, along with the certified copy of the order past hearing.
27 is so similar also. All the rules.
Direction.
Please, your lordship.
What is this? Non-payment,
Non-payment of fees.
admitted. How much?
Your lordship, as per our instruction, lordship, real amount from period 1 to 20 to 25 to 20, lordship, they have already received. I don't know, kindly pay the instruction, lordship. Other part, lordship.
It has not been verified.
Lordship, lordship. Other part is so, lordship, may posted after 2 weeks, then lordship, I can get update instructions.
The instructions so placed by Mr. K. Gogoi, the learned additional senior government advocate, is not conclusive as to whether the petitioner herein is entitled to any amount.
Lordship.
The said instruction is kept on record and marked with the letter X. Taking into account the instructions, the contents of the instructions, this court fixes this matter on 18th of September 2026 for an update. The respondents shall verify to the entitlement of the petitioner and place the update on the next day.
What's up, please?
Lordship,
Yes, Mr. J.
Lordship.
Gauhati.
I have to file an affidavit, Lordship, in both the cases, Lordship. Although, Lordship, in item
913.
29,
29.
29, Lordship, yesterday only we received the extra copy, Lordship. In item 28, Lordship, so, 15 days further time is required to submit.
Work is for what?
Lordship. Yeah, the water is a water treatment plant is a water tank.
Construction of
Lordship.
mobile number.
So have you awarded the contract to somebody?
Yes, Lordship. Yes.
To whom?
Is
Contract for, what contract is there?
it is Lordship. Lordship, it is no, NIT is page 84, Lordship. The construction of new Bakihola town piped water supply scheme, Lordship. Under tight grant 15 finance commission for the year of 21-22, Lordship.
What do you mean by minimum average annual turnover? Means combined 3 years, the annual turnover should be not combined. The combined an average of the last 3 years.
Last year.
Should be 5 crores. What is wrong in these terms?
Lordship, actually we are challenging the conditions.
Why?
Uh,
What is wrong in these terms?
Lordship, if you see the page number 51 of writ petition 913 here, it is written that the bidder shall have the executed works under PHE department with a cumulative value not less than twice of the tendered amount. Lordship, we have similar experience in other department, and as per the petitioner, Lordship, they think that these are tailor-made conditions. That they,
PHE. They say about water resource
PHE department.
who possesses similar works of civil works related to water resource management. You are challenging clause 1, 3 and 11.
If you see the eligibility criteria and paragraph number 8, I mean point number 8,
it tells what are the terms of the tender? 1.
page number 51, writ petition 913.
Targeted completion throughout course of fund, eligibility area. The invitation for bids is open to all registered firms of water resource department and our municipal board.
Lordship, we are registered under Titapur Municipal Board.
You are?
Yes, Lordship.
Then there is no problem.
Yes, and but they have put another condition, that is at condition number 8.
Bidders should neither be associated nor be associated. Then 3 is 1. What is 1? What is the problem with 1? Have completed the works by the targeted completion of the year specified in month will have the right to demand throughout this tender. Then 11 must have the minimum average annual turnover of 5 years for the last 3 years. Then what is wrong? You don't have 3 years, 5 years, 5 crores average.
Lordship.
Huh?
Lordship, we have fulfilled all the conditions apart from that executed works on the PHE department. We didn't.
We have the 5 crores.
Uh,
Then why you
annual turnover is of rupees 1 crore, Lordship. It is written as 1 crore.
No, page 52.
Page 52. No, we do not have 5 crores, Lordship.
So,
Lordship.
you don't have 5 crores. What is this type of tender? Why are you challenging it? You had Titabar, there is no problem with that.
Lordship.
They may, this is for what? Water treatment plant.
Water treatment plant.
Then they will want to water people, water resource department. What is wrong?
Lordship.
Not today, I won't dismiss it. Oil and file an affidavit.
Lordship.
When are you filing it?
15 days required.
Huh?
15 days.
File your affidavit
Yes, I will file.
and file affidavit along with documents, huh?
Yes, Lordship. Yes, Lordship.
Mr. J.K. Goswami, the council appearing on behalf of the Titabar Municipal Board,
Respondent,
And why there are two writ petitions?
one is, there are two different NITs, Lordship,
Same similar conditions.
similar conditions.
On behalf of the respondent, Itabor Municipal Board.
3 and
seek
4.
For some time. Seeks for an additional period of 15 days for filing the affidavit in opposition. So taking into account the reasons so assigned in the communication dated 13/8/2026. It is the opinion of this court that the respondent Itabor Municipal Board is required, should be granted certain time. Accordingly, list this matter on 14th of September 2026. In the meantime, the reply be filed on or before 7th of September 2026. Affidavit in opposition be filed by 7th. Petitioner would be at liberty to file the reply there against.
Lordship.
This court shall consider the intake as to whether there is a requirement of passing a shall consider on the next day as to whether the repetition, whether an interim order is required to be passed. The council, your petition has become infructuous. It has already been given to a third party.
Lordship, we have heard that they have given. But
So, unless you don't challenge his appointment, can we say anything that the terms are bad now?
subsequently they passed that order.
So what?
After filing notice.
Third party rights have not been involved. Can we pass an order?
Lordship, will file an additional affidavit.
Think about it. Additional
No,
affidavit. This is a wrong. Duita take order.
Lordship.
Yes.
Yes, in this case also third party right has been created.
Huh?
Contact has been awarded to
Whether the evaluation of the notice for the selection of a month have been filed and for any bidder have been selected. So you can do action. Technical bid have been rejected.
Lordship. On the date of issuing notice of motion, Lordship, keeping in view the public interest, the interim order was not entertained.
Why are you challenging the notice inviting tender?
And, Lordship, the subsequent notice, Lordship. The subsequent notice, because in the first notice, after the tender was invited, Lordship, there were some amendments, Lordship. And that were not brought to the notice of the petitioner, Lordship. The subsequent amendment to the initial NIT, Lordship. And that's why we have challenged both. The subsequent NIT also, and with a prayer to restore the original NIT.
So that was done on 13/2/2026. Where was it published?
Please, Lordship,
This is pertaining to what?
BD is public to NFSA rights, Lordship, transportation and carriage. And when it was
Where is the
tender, Lordship, the first tender,
Where is the second tender?
second tender, Lordship, it is in page 71, Lordship. Page 71 onwards.
This is the second one.
The second one, Lordship.
What is wrong?
No, Lordship, in the first tender,
We submitted our bid lordship, and
then-
thereafter our bid has been rejected, saying that we have not given the registered office document FSSL license submitted for the state of Bihar, contract labor license submitted for the state of Bihar lordship. Those conditions were not included in the original NIT lordship.
But how can there be settlement being made in your favor by this tender?
No lordship, the first tender. First tender.
First tender also, how is the settlement can be permissible?
No lordship, we are challenging the subsequent amendments also without bringing it to the subsequent lordship knows it very well, subsequent amendments are barred.
Subsequent is at page 71.
A subsequent NIT, the first NIT has been cancelled because there was no competent bidder lordship.
Then
Then the second NIT has been called.
where is the second NIT?
There's a page 71 onwards. lordship.
Second NIT, this
Yes,
is
lordship.
11-2.
11 2.
You are challenging this.
Yes, yes. lordship.
Why?
And also restoring the original NIT lordship. Because the declaration, the declaration rejection of the bid of the present petitioner lordship in technical bid, that was improper. Because the amendments were made, brought in subsequent to the calling of the NIT lordship. In the original NIT, those were not there. Page 29 lordship.
It has been given to whom?
June. Lordship, it is settled in the month of June.
And you have not challenged this.
No, look, and today only I have, on the last date, I was not aware of it, lordship. Lordship, may I take instruction from the petitioner lordship whether he wants to pursue or bring some amendments in the petition lordship?
Thus, I have passed an order today.
Lordship,
Did you hear? You're not present.
may not be, lordship.
But interestingly, when I delivered the judgment, an interesting observation I have made. Clause 7.1 forbids lifting by anybody else but authorized. 7.11 gives the state the power. So once it is being lifted by the state,
Then it can be.
7.11 can be carried out for transportation. This is what I have said. But here the problem is the lifting is also being done.
Yes, lordship. That's false.
So if it is lifted first and then done, it is better. Then the problem with 7.1 does not come because 7.1 only says lifting.
NFS.
7.11 does not say. But here also this tender, the same problem has happened. In fact, the meaning which I have given today appears to be more logical. For transportation, there is no bar. But for lifting, there is a bar. And I think there is a reason why. Because the lifting is being done by the authorized agency only for the purpose that there is something, some accountability is there. So that the transportation, if it is done by through him, so if tomorrow the deputy commissioner lifts it and then gets it transported, it is a different thing. But the NIT as it is cannot, because you are lifting, transporting from FCI Godown. So their lifting has to be there from so and so. Lifting has to be from the custody of the deputy commissioner. If it is done, then I think this is the only way out for the state. Okay, in pursuant to the order passed by this court on 10/8/2026, Mr. M. Setia, the learned counsel appearing on behalf of District Commissioner Lakhimpur, had submitted, have placed the order dated 18/6/2026, whereby one MS Free Salt was appointed as the handling contractor oblique transportator for both Tier 1 and Tier 2 for transportation of food grains under the NFSA 13 for financial year 2026-27 in respect to Lakhimpur district. The said instruction is kept on record and marked with the letter X. Mr. D. Das, the learning counsel appearing on behalf of the petitioner, submits that as the said order have not been put to challenge, he would obtain instruction as to how to proceed with the present proceedings. Is this matter when?
Next week. Next week, Lordship.
Is the matter again on 21st?
Lordship.
What is this? One second.
My pleasure, Honor. Response number 2 has stopped the release of the payment by the letter dated on 29 November 23 and asking for a detailed inquiry report. And as per the requirement, inquiry report also submitted by the Deputy Commissioner. And by letter dated
What the money?
page number 34.
What the money?
No, my lord.
Why you are not paying?
Lordship, actually, as Dr. informed me that he is preparing the affidavit.
Who?
So, as Dr. preparing.
My lord, from last 3 occasions, they took time to file the affidavit from April onwards.
We will file our affidavit.
You filed a petition in 2026.
26, yeah.
We can give some leverage. Notice was only issued on 9/3. There are a lot of people who are not getting anything. A final opportunity is granted to the respondents in the PNRD to file the affidavit as to whether the petitioner is entitled to the amount of rupees 12,91,000 as claimed in the writ petition. And further, when the said amount would be paid. This matter taking into account that on 3 different occasions, times have been taken by Mr. S. Dotto, the Learned Standing Counsel of the PNRD, a final opportunity is granted to bring on record the said affidavit. List this matter on 2nd of September 2026. In the meantime, the affidavit be filed on or before 26th of August. What is this?
This is also regarding non-payment
Which
of the,
department?
my lord, this is water resource, my lord.
Any problem with these people? Brahmaputra board and all?
My lord, they have filed their affidavit saying that they are not required to pay anything in this project. They are not supposed to make any payment in this project, my lord. I have to take instruction on this, my lord. I'm seeking a further 10
Ms.
days.
P. Chakraborty, appearing on behalf of the Water Resource
Ma'am.
Department, submits that in view of the stand taken by the respondent number 1 and 2 in the affidavit filed on 36 to 37, 2026, she would like to obtain instructions from the Water Resource Department of the Government of Assam. List this matter on 24th of August 2026. In the meantime, the affidavit be filed on behalf of the Water Resource Department.
Obliged.
May I please, Your Lordship? Your Lordship,
Hmm.
this matter pertains to non-payment of contractual bills, Your Lordship.
I have received instruction.
I have received instruction, Lord.
What is your instruction?
Now, it is with the fund is with the mission director, Lordship.
For Mr. Bora, I have put a mic there.
For
Yes.
March, my lord. My lord, on 2nd March, 26th, my lord. And was released to BTC.
BTC. You say that you have given to BTC and BTC says?
Then instruction has come, I have gone through the instruction. Now, Khan has already turned back to again to assess them. Now they will write to again assess to again to release the funds. due to some technical issues, Lordship. That is why return back. Some technical issues was arise. That is why fund was.
What is the entitlement of the petitioner?
Your lordship, 70 lakhs, your lordship, 48,400.
Therefore, the payment.
Lordship goes to the page number 59.
The payment has already been sanctioned, released. Payment released to BTC,
Released by the BTC, Lordship.
BTC, by Mission Directors SSA.
Yes, sir.
Then amount of so and so is hereby released as first installment.
Yes. Gone.
Now, the petitioner, then the BTC returned it to you.
The instruction is today's instruction.
Return to you was received through PFS dated demand for the work so and so, so and so. Said amount was subsequently returned to you due to certain technical issues in the FMS, particularly with regard to the addition of the beneficiaries, which resulted in the inability to release before so and so. Subsequently, BTC so and so for sanction and release of the amount for completion of the aforesaid work. However, the requested amount is yet to be received. Okay. So you again have to send it to him. Okay.
You will have to write to.
The entitlement of the petitioner as claimed in the instant with petition is rupees 70 lakhs 48,400. This aspect is duly admitted both by the BTC as well as the SSA. This aspect by SSA, as would be apparent from the communication issued by the Mission Director SSA dated 2/3/2026, whereby the said amount was released to the Principal Secretary BTC for further disbursement. It further appears from an instruction placed by Mr. So-and-so, the learned counsel appearing on behalf of the standing counsel of the BTC, that the said amount of rupees 70 lakhs 48,400 was thereafter on account of addition on account of a technical issue in the PFMS system as regards addition of the beneficiary was returned back to the SSA. The BTC authority thereupon again on 16th of June 2026 again sought the said amount from the SSA. However, on account of the said amount having not been paid by the SSA, the BTC is not in a position to disburse the amount to the petitioner. The instruction so placed by Mr. So-and-so is kept on record and marked, for the standing counsel is kept on record and marked with the letter X. Mr. Espora, the learned standing counsel of the SSA, shall provide an update as to what steps have been taken in pursuance to the communication dated 16/6/2026 on the next date. List this matter on 23rd of September 2026. In the meantime, it shall not be the pendency of the writ petition shall not be a bar on the part of the respondent authorities to settle their issues, and thereupon disperse the amount to the petitioner. An update be placed on the next date.
Much of.
Mr. Goswami, what is this?
No, this is for refund of an amount, my lord, deposited by the petitioner on account of a lease settled with him, my lord. But the possession thereof couldn't be handed over. That is the admitted position, my lord.
What
My
is
lord.
this? Is it covered by this judgment?
Actually, my lord, we need clarification if it is same or not. We have sent an affidavit.
Time
for
and
it.
again, they are initially.
So
they
my
are
lord may consider it a delay also. My lord may see it is that from 2015, my lord, the issue. After 5 years, twice they have sent representation just to drag this matter, my lord. Only after a favorable order in the other two cases, my lord, the petitioner has approached this court.
You mean to say fence sitter?
That could be the word, my lord.
That would be the proper word.
Yes, ma'am.
Alia affidavit. You were only asked as to whether it will covered by the judgment of this court. Now the question is, if it covers, then obviously he will be entitled to.
Yes.
If it doesn't cover, it is not. But the fact remains that those writ petitions were filed in the year 2016.
Mm.
And the petitioner has approached this court in
No, they are the reason.
after
They are
10
the
years.
reason. Bakizai proceedings were drawn against them, my lord. So they had to come, my lord.
Anyways,
And there's an
let
interim
us-
order, my lord.
You file your affidavit. Mr. Ibo Thakur, the learned standing counsel of the Forest Department. Submits that 2 weeks' time may be granted to bring on record their stand. It is noticed that on the earlier occasions, on 2 occasions earlier, the Forest Department had already taken time. The further issue involved in the present proceeding is to whether the petitioner herein is similarly situated with the writ petitioner in WPC number 6139/2016 and accordingly entitled to the similar reliefs as per the similar reliefs as directed in the judgment dated in the order dated 11/9/2025.
My lord.
Pusto. The respondents in the Forest Department would be at liberty to take various be at liberty to take the issue of maintainability of the writ petition in the affidavit in opposition. File it. List this matter on 7th of September 2026. In the meantime, the affidavit, a final opportunity is granted to file that.
Grateful.
Milai dibo, huh? What is this?
An extra copy they have given us yesterday also.
What is the liquor shop doing here? Interest subsidy on liquor? No. You have not filed affidavit.
Yesterday they have given the copy. to
Lordship,
us
due
also.
to some error of,
You gave the copy yesterday.
Lordship, due to some error of submitting the extra copy, so we have rectified it.
Okay,
from
Mr.
yesterday.
K. Gogoi, the learned CGC.
Lordship, no, I'm for state government, she's for CDC.
Earlier you were appearing for CGC.
But that
We
day-
can't help you.
That day nobody was there. Lordship. That's
So what? You cannot. That is why I say that you have become, means it is very difficult to say. Others, there is no problem. You keep on changing colors. Here, here you are accepting, Mr. K. Gogoi learned here accepts, CGC accepts notice on behalf of respondent. Whereas Mr. G. Vokel, the learned counsel accepts notice for 2, 3, and 4, and 5.
Then, Lordship, my
And
sister-
today, you become CGC, how is it possible?
My sister and Lordship, Setia will take this.
No. Who are CGC?
Lordship, I'll do.
You can't have him because the records are wrong. Okay, the counsels appearing on behalf of the respondents submitted that only yesterday copies of the petitions were served. Taking into account the above, list this matter on 1st of December 2026. In the meantime, the reply affidavit in opposition be filed by the respondents on or before 23rd of November 2026. Yes, what is this?
This is pursuant to a 16(1) application under the Indian we are a telegraph authority, my lord. And
You are?
we are a telegraph authority.
Ah.
We are undertaking transmission of power lines, which is of national importance. But we have not been able to access the right of way due to the obstruction of the landowners. Subsequently, we wrote to the district administration of both the districts, but no help was forthcoming, so we had to file these writ petitions.
Have the compensation been already fixed?
No, because we have not been able to enter.
Why do you need to enter?
My lord.
You enter, then you pay.
No, my lord.
Then
what the yesterday?
No, what does Section 10 of the Indian Telegraph Act say?
My lord.
They have already, out of 61 Lordship, 31 they have completed Lordship. Obstruction is there Lordship, we have cleared the obstruction, 31 they have already completed. Out of 61, due to the election period Lordship, that was not done other parts. We have filed affidavit. So Lordship may give some time, I will obtain instruction with the remaining part, the obstruction was cleared or not Lordship.
But have they paid the compensation?
No, we have already deposited with the district administration.
We have not done.
You have deposited. Where is the statement?
My lord, will
you cannot
apprise my lord will apprise the court regarding the amount of compensation.
And what is Mr. Khera doing?
My lord,
My lord, I'm assisting.
Oh, you're assisting from there. My goodness.
My lord, what is
My
happening
lord,
is that
I could not travel for some personal difficulty, my lord.
Yes.
So, my lord, in the affidavit, they've stated that there are certain irregularities committed by us, but they've not specified as to what kind of irregularities we have committed. So, they should clarify this before the court.
You say first whether you have paid your compensation. Without saying that, why should we entertain this type of petition?
No, my lord, the compensation is due. Compensation is with the district magistrate, my lord. But the only thing is that.
How do I know? Isn't it a requirement of that statement in your affidavit?
My lord,
and the payment out there, the receipts out there, that you did not go and pay this by some use your wallet out there and pay the amount. You must have paid by some transfer by NEFT or so and so. So these are all documented. Why these are not being
of course, my lord. This has
and
to be
if the repetition, Mr. Gugoi, if the repetition is bereft of those materials, I think we should dismiss the petition on that.
It's a company, cost should be there.
No, I think we need to dismiss. Well, let's dismiss. At the end of the day, something needs to be done. Yes, Mr. Assisting Counsel, what are you doing? Why on earth didn't you mention it in your petition? You are the Assisting Counsel. This
My lord.
fault is yours.
My lord.
It is yours,
My lord.
absolutely your fault. It
My
can't
lord.
be the fault of the senior counsel.
Absolutely not. My lord.
Then why haven't you enclosed that?
My lord. My lord, we have another grievance in this, my lord.
Is your petition on account of inadequate pleadings? We cannot allow
my
this
lord,
type of petition. We dismiss
my lord,
it. No,
my
no.
lord may give us a 1 day's opportunity. I'll file an affidavit bringing all on record, my lord.
Cost on Mr. Khera. Upon you. You are the person who is responsible. How much? 30, how much? So many people.
Today's Lordship,
Okay.
today's Kuta Lordship not fill up.
45,000 each. 31
My
is
lord,
left. 31,000 each.
My lord, may give us chance, my lord. I'll file one affidavit, bring all the other details on record.
Very disappointing.
My lord, I'm sorry.
You need to be
for
sorry.
my lord, we'll bring it on record, my lord. The another issue here is, my lord, that they are doing the construction while once we have cleared and gone ahead, again they are trying to make some construction after the way has been determined and identified, my lord, landowners, just for enhancement of
Khera,
compensation.
You are not to argue.
My
You
lord.
only reply of only as regards your inadequate pleadings. For arguing, Mr. Sharma is there.
My lord.
You are only to argue out here, reply on account of inadequate pleadings. So the cost therefore is upon you.
My lord, may give me one date's opportunity. I'll file an affidavit. Within 48 hours, I'll file an affidavit, bringing all data on record with an endeavor for my lord's satisfaction on it.
It is seen that the respondent states have filed an affidavit in opposition, wherein it is mentioned that out of 61,
Yes, yeah, out of 61
61, 31 have been
completed.
completed. And Mr. K. Gogoi, the learned additional senior government advocate, submits that he will obtain an updated information as regards the further progress being made by the district administration. Mr. R. Sharma, the learned senior counsel, appearing on behalf of the petitioner, further submitted that though certain constructions have been carried out, but in the meantime, there is still certain encroachment. Mr. K. Gogoi, the learned additional senior government advocate, shall apprise this court on the next date. List this matter again on 9th of September 2026 for an update.
39 is same order, man.
How many? 61. Same. One order te duta logai. Yes, what is this SOPD?
Obliged, my lord. I apologize, my lord.
No problem, Mr. Khair.
Please,
Is this-
Lordship. Non-payment of expenditure of amount, Lordship. Non-payment of expenditure amount, Lordship. Because petitioner has.
In the forest department, no Tamser Ali.
Yes.
Department, yes.
No Tamser.
Lordship, in this
We
case,
don't have.
Lordship, in this
Do
case,
one thing. Well, period for what?
Lordship, in this case, petitioner has completed more than 70% of it. But after completion of 70%, Lordship, without cancellation or termination, they have retendered, Lordship. So petitioner, before your Lordship, they have filed representation to clear the expenditure amount, but it was not considered.
Yes, file your affidavit.
Yes.
This is important. Mr. Botago, appearing on behalf of the forest department, submits the 3 weeks time may be granted to file the affidavit. This court specifically inquired with Mr. Botago as to whether there is a maintenance of a chronological register in the forest department so that the observations made in Tamser Ali versus State of Assam reported in so-and-so can be applied. It has been submitted that forest department, there is no chronological register being maintained. Accordingly, it is the opinion of this court that the judgment of the full bench in the case of Tamser Ali, Supra, would not apply in the instant case. The respondents, therefore, the respondents shall bring on record its stand by filing the affidavits on or before 9th of September 2026. List this matter on 16th of September 2026.
Highly obliged.
Because if you have Tamser Ali brought in, it becomes a big problem.
Yes, Lordship.
In this case, if it is said that Tamser, you cannot file
In
a
this case,
contempt.
bidding authority already forwarded the higher authority.
Understood, but the problem is if this order remains as Tamser Ali,
Earlier.
you cannot file a contempt.
Yes, Lordship. Obliged, Lordship.
What are these?
My lord, I have just received the affidavit filed by the state, my lord.
We have served the copy now, madam. What is your stand? Either for what?
The work orders were not issued. It was a preliminary work order with the rider test, my lord. Only upon receiving the administrative approval, it will be, my lord, the formal work order will be issued. That was never received, my lord. He worked for about 6 months and thereafter, my lord, work was over. Now, my lord, for this financial year, my lord, new tender has been floated and work order has been issued.
I think we need to dispose it of on the next date. Yeah.
Only
Reply,
one
affidavit in oppositions have been filed by the state.
Yeah.
In the present, in the
Respondent
present
two,
batch of petitions
Respondent number 2.
by the respondent number 2 in the present batch of petitions. This court also takes note of that there is an interim order operating. So considering the above, this matter on 21st of, we finish it off on 25th at 2 p.m. On 25th of August at 3 p.m. Full stop. In the meantime, if the petitioner is desirous, would be at liberty to file reply on or before 24th of August 2026.
Not
Interim order shall pass earlier shall continue till the next day.
obliged.
Non-payment. What is this? Your stand.
Instructions are awaited, man. Waiting for some.
Mr. So-and-so appearing on behalf of the petitioner, on behalf of the PHE department. PHE,
PH.
on behalf of the respondent submits that the instructions are awaited considering the above. This matter again on fourth of November 2026. In the meantime, the respondent shall bring on record its stand by filing the affidavit on or before 12th of October 2026. The petitioner would be on 6th of November, shall file the affidavit on or before 2nd of November 2026 as to whether there is a state to the communication. You're challenging this.
Yes, my lord. To resume the
Where's the communication?
page number 50, my lord. The last communication.
Mr. Counsel, why are you delaying this matter? This is, you see, if we delay, see the order, impugn order, 25/26/5/2026. Resuming execution of the work, refixing or extension of the work completion timeline for scheme under JMM. With reference to the area, please find enclosed herewith a letter issued by the chief engineer so-and-so. With regard, you are therefore requested to complete the allotted work, including trial run, bill submission, so-and-so. So if you are delaying it, is it in your interest? File your affidavit next week. Full stop. Taking into account the issue involved. Full stop. The Mr. Ibotaku, the learned counsel appearing on behalf of the respondent submits that the affidavit would be filed by 24th of August 2026. Full stop. List this matter on 27th of August 2026 at 3 p.m. You file it Once you file it, we can, because otherwise the work will remain as it is.
Water supplier should have
No, this will have a far-reaching consequence.
obliged.
May I please, as per the last order 24/6/20, the affidavit has been filed by the BTC and the assessment has been made. And now,
Yes, you have provided.
Yes, sir.
You have made the assessment.
yes,
Yes,
they have
yes, sir.
assessment, but
Have you now provide, where's the assessment? You have filed an affidavit. Where is it?
it is not in a record. Yesterday,
Huh?
yesterday they have filed.
Yesterday only filed.
You
Last page,
provided
yes.
the assessment.
Yes. Now, question is, who is paid the amount?
For how many years?
2008 to 2021.
Is a building also?
Yes, Assam type house was.
2008 to 2012.
Building value of Assam type house is 43 lakhs. How big is the building?
As per lordship, for the period from 2008 to 2021.
Huh?
For the
2000
period from 2008 to 2021.
You're not on that. How are you putting the building value at 43 lakhs if it is an Assam type house in the year 2008? How? Be reasonable.
Yes, lordship.
Rent.
Then you plus building value.
Land value plus.
It's a headache. You have a copy of this? You just show it to you. Is it? Should it be done in this manner? I never thought that it would be done. You have to take the, no, what we have done is, why you're taking the land and all, you have to take the annual rental value of the building. Are you saying that the rate at that point of time was 36,000 for that value? What was the government running rate at that point of time? What is the square feet of the building? This is how you take it. And the building value is more and land value is less. You ever heard of?
Land value is 50,000.
Huh?
Land value is 50,000.
And the building is 43 lakhs. This is not done. Do it properly. He's not getting it. Mr. Counsel, I don't see them in a position to do it. I don't know what has happened to the BTC. They don't know head and tail how it is to be done. What is the rental value at that point of time? Just find out and place it before this court.
I'll try.
On the basis of that, Mr. I think that is a better option. Asking them to give this 46 lakhs. Never heard of that.
Our claim is given us
In pursuance to the order passed by this court on 24/6/2026, directing the Secretary Land Revenue of the BTC to make calculation of the compensation payable to the petitioner in terms with section 11(4) of the Act of 1964. An additional affidavit, an affidavit in opposition has been filed by the Secretary BTC, wherein the assessment has been made that the petitioner's entitlement is rupees 46,42,358. A perusal of the calculation so made on the face of it appears to be incorrect. Full stop. This court have asked the counsel appearing on behalf of the petitioner to place as to what was this court have directs the counsel, the petitioner as well as the BTC to place before this court as to what was the rental value of a building of the size of an Assam type house with similar to the Assam type house standing on the land in the year 2008 on the next date. This matter again on 9th of September.
I'll try.
This is not done, Mr. Counsel. Some BTC, you have to do some.
Inspection report, that is.
Is it ever heard of the land value is less than the building? Land value is 50,000, building value is 41 lakhs. Who is going to help you out? Yes, what is this? Additional affidavit file? No.
Your Lordship, I am the petitioner.
You have
I
not
am the
filed the
petitioner
additional
for three
affidavit.
cases, 53, 54 and 55. All are identical in nature and common issue.
Understood. Somebody took time for filing additional affidavit.
That not required.
Yes. You're not going to file.
No. Already your Lordship has passed the order on 14/8. Last of.
The counsel appearing on behalf of the petitioner submits that no additional affidavit would be filed in all the three petitions. Now, what is required to be done?
Now, my lord, this case is pending since 10 years, last 10 years.
Huh?
Last 10 years, this is a barter trade.
This is a 2021.
Yes, 21 case.
Till from 21 to 26 is
There
10
is-
or 5 years.
Yeah.
Then, what is the matter about?
Matter is there's a default of barter trade arose due to abrupt closure of the
Default of?
barter trade. I am an exporter and importer.
Uh,
So defaulter of barter trade arose due to the abrupt closure of the barter trade. I refer, my lord, the barter trade agreement.
Port payment of rupees so and so as on closure was not allowed to be balanced either by export of so and so. So you are challenging an RBI circular.
My lord?
You are challenging an RBI circular.
Yes, RBI circular. Not challenging, that is, RBI circular is 16/10/2000 annexure 3,
Ah.
42 to 45.
But why the respondents have not filed the
Yes,
affidavit?
they are not filing a affidavit. Because it is,
Chalo, anyways.
they have taken twice time to file affidavit.
The learned counsels appearing on behalf of the petitioner submits that the petitioners would not be filing any additional affidavit in the present batch of writ petitions. It is also noticed that the respondents have not brought on record their stand, though the writ petitions have been pending since 2021. A final opportunity is granted to the respondents to bring on record their stand by filing the affidavits, failing which this court shall dispose of the writ petition based only on the materials on record. Full stop. List this matter on 18th of September 2026, comma. The affidavits be filed on by the respondents. The final opportunity to file the affidavits on behalf of the respondents is given till 16th of September 2026.
So 18th, instead of 18th of September, another date may be 18th of September, I'm in Shillong. 18th September.
25th.
Yes, yes. Much obliged.
Itu that affidavit 2 will be 22nd. Huh? What is this?
They are paying the remission of 100%, Lordship. Our affidavit will be fine.
You have filed your affidavit?
Yes, Lordship.
Okay. Taking into account that the respondent have filed the affidavit on 9/7/2026, a final opportunity is granted to the petitioner to bring on record their stand by filing the affidavit. What is the interim order passed? For the ends of justice, the interim order passed on 15/12/2025 stands extended till the next date. List this matter on 9th of September 2026. Ankitasi. Affidavit filed.
No, Lordship.
There is a dispute between the two petitioners, that one is private restaurant and another is petitioner. Both did you have a dispute of this that respondent number 6 and 7 and 8, the direct cannot be.
Huh?
Direct cannot be made. That dispute, the one giving a division has been.
You have not moved under 3H4.
Lordship, our problem here, Lordship, Lordship, in item number 58, petitioner claimed that their land was acquired. Actually, they are the co-partner in respect of DAG number 497. And Lordship, there is a Lordship, land was Lordship identified by the authority and a report was prepared, but that report was not challenged by the Lordship petitioner in item number 58. His land was not acquired. Only my land was acquired.
Now,
But-
why the payment has not been made?
It is because of the objection raised by this petition respondent, Lordship.
So therefore, isn't it your requirement that this court cannot look into it? The 3H4 court will look into it.
Lordship, kindly have a look at page 61. For a moment, Lordship.
Not possible.
Authority, Lordship, demarcate the land, and it is Lordship.
Mr. Mohammed, if there is a dispute, the only way out is 3H4. Who's entitled? I can't help you with that. Payment has already been deposited under 3H1. So therefore, the payment, if there is a dispute between both, under no circumstances under 3H3, the amount can be distributed between you or them.
Right.
So therefore, if there is a dispute, you need to file an application, then rightly refer it to the principal judge before whom it is.
Lordship, that
We finish it off on the next date.
Lordship,
That is the only way out.
Lordship,
There's
Lordship, Lordship.
Is this matter on, was taking into account the issue involved. list this matter on 19th of August 2026, 2 p.m. for final discussion.
Like.
Right.
You're supposed to file the affidavit to bring on record the.
You filed it?
No, no, we're taking more time. Next week we file.
No.
Project has been desanctioned, and the ministry has given the approval on 12/8, recently.
From 31/7 till date, if you can't file it, can't help you. The simple thing, I've asked you to only bring on record that's.
Yes, I have already sent it, from officers are not present. By Monday, can file.
The Central Government Standing Council. Mr. H. Gupta, the Central Government Standing Council seeks for a further opportunity to file the affidavit, additional affidavit, to file the affidavit as was directed on 31/7/2026, as was earlier directed. This matter on 18th of September 2026. In the meantime, the affidavit be filed.